unless it is mentioned, I will not come to the court. So that has created problem for me. Let it come on the 19th with an observation, it will be taken up on 19th. I'll be deeply obliged. Item 72. Was it judicial order?
Yes.
But it should reach by tomorrow. Normally, it's 72, so I'm expecting it to reach by tomorrow.
Might not, sir. If my lordship keep it to 19th, it will be better. Then he gets enough time. He will not say, I've got no time.
No, I've said that the last order was that list this matter in the week commencing 15th April.
Yes.
So it has been listed. It's immediately listed.
It has been listed.
If you want to be taken up on Friday, so it means you are passing it over.
Yes, that is true.
Pass over to be taken up on 9th. Please inform the other side if you can.
I am informing, but the side is saying, unless it is mentioned, I will not go.
No, it will be taken up on
Friday, 19th.
Yes.
Second appeals. And the state is now taking over the position of the land. That is the urgency. The reversing judgment.
Second appeals, actually, the assignment was changed on last Friday. So this has not been reflected in the list as such because the list was already prepared. You give your memos, I'll see if it can be done. At least this week there will be some here and there, but from next week onwards we'll regularize it.
I don't know what urgency is there. The state is going to TC CP 476 of 2017. The Lordship had the matter on 23/11/2020. And next week, I also
I want to mention, my lord, this is RSA 2018 matter, my lord.
RSA don't mention today unless it is exceptionally urgent. Don't mention because as I said just now.
My lord, yes.
So there may be some difficulty. You may file your memo if you want. We'll see.
The residential house construction material laws.
Yes.
So.
Tired of bail matters.
Correction of order. I for correction of order.
tired of bail matters.
Tired of matter
I pay 10 years, my lord. Out of 10 years, my lord, 6 years.
matter 10 years out of it.
I want to make a mention, my lord. That matter, your lordship may remember that matter. 3 dates are difference, my lord. The bail matter, my lord. Your lordship is specifically adjourned today, my lord. But it has not
come.
Tomorrow, your lordship.
Weekly supplementary weekly list supplementary list
But it's a tied up BLAPL matter, but an IA has been filed, IA 320 of 2024, praying for interim bail on medical grounds, my lords. The last time it was listed, my lord had directed specifically to be taken up today with instructions were sought for the statement.
I'm important to mention, my lord.
Yes.
There is one bail application that is 13,418 filed in the month of November 2023. That has not been listed, and recently his uncle has died about 3 days back in a hospital.
You are wasting the time.
Sir, BLPLA 13274 by 2023 million. It is yet to be enlisted. It was first posted on 512 million. Thereafter on 201 in the Court of Justice Savitri Ratha Madam Miller. So it may kindly be taken.
Have you filed any memo?
I have filed more than half a dozen memos.
Today have you filed memo? Today how many memos have you filed?
Today I have not filed, but last week I had filed.
That is it. If you want to remain content with your half a dozen memos, then be content with it. Today, if there is no memo, I will not pass any order. Yes, item 1.
I'll file today.
Item number 1, my lord. The first content matter, my lord. Not content.
What is the meaning of first content, Mr. Patnaik? Contempt of Courts Act ଅଛି? ମୁଁ ଜାଣି ନାହିଁ ମୁଁ ଦଳକୁ ଆସି ଆଜ୍ଞା ପ୍ରାକ୍ଟିସ କରିକି ମାନେ ମୁଁ କାଳେ ଏଠି ହାଇକୋର୍ଟରେ ପ୍ରାକ୍ଟିସ କରୁଥିଲି ନାଇଁ ଫାଷ୍ଟ କଣ୍ଟେମ୍ପ୍ଟ ଯଦି ଆପଣ ପ୍ରେସ୍ କରିବେ ତାହେଲେ ଏଟାକୁ ପ୍ରେସ୍ କରନ୍ତୁ କାରଣ ମୁଁ ଜାଣିନି ଫାଷ୍ଟ କଣ୍ଟେମ୍ପ୍ଟ ମୁଁ କରିପାରିବିନି
Sorry,
what first contempt what Mr. Patnaik if you have filed a contempt press it yes
my lord.
which order
Under Amendment 1, my lord. Page 6, my lord.
Page 6.
Page 11 and 12.
11,
Page 11 and 12. Yes.
11
What is the direction?
Directed
For the complete petition of the petition under Annex 6 in accordance with after giving opportunity of hearing the petition, all concerned preferably within a period of 4 weeks.
my lord.
So this order was passed on 14th.
So 14/12
Yes, why has it not been complied?
Yeah, I will have to take
This is
instruction.
an innocuous order.
Might have been complied.
Yes, yes. Learned AG shall inform the court as to why the order dated 14/12/2022 passed by this court in WPC number 30333 of 2022 has not been complied with, comma, as alleged by the petitioner. List this matter on 29th April. Yes.
Item number 2.
May I please, my item 2, the petitioner paid for transfer of civil petition pending before Family Court Barampur to Bhubaneswar. And what happened? Earlier the petitioner approached this, the respondent opposite party has approached this honorable court for transfer this case from Bhubaneswar to Barampur on the ground that since she is working on Barampur, for that reason, but she did not attend the court, always taking time. But in the meantime, he has been stated one double is that I am working at Silchar, my para 4, Silchar Guwahati, because since the
So she is not attending.
Attending,
She is not attending.
My- and-
So will that give you a ground to transfer the case back?
why I'm saying so, my lord? Because on the ground of that, she is working at Barampur for that reason, because I am working.
You could take in that case against her, whatever you can do.
My lord, they are
In the
not
absence
setting.
of a party, in the
My lord.
absence of a party, any order that any order that is.
That they are not.
Again, सुनो तो,
My lord, sir.
this case, this court directed the case to be transferred from Bhubaneswar to Ganjar.
My lord.
No, only because the opposite party is not appearing, he wants it to be transferred back to both.
On the ground that he is working at Silchar Guwahati. Now he is working at Silchar Guwahati.
Maybe.
For that reason, because if he is Guwahati, so he will come across the Bhubaneswar, my lord. For that reason, because on that.
Who is working at Silchar? You are working.
No, my lord.
How?
The opposite party, my lord.
So, how is that,
On the ground of that, I am working at Barampur. He has filed a transfer petition and taken the.
Wherever she, because she is transferred,
My lord.
every time the case will be transferred back.
For that reason, my lord, earlier.
No.
My short, my lord. For that ground, the petition has been.
No. Considering the petition transfer application filed earlier by the opposite party,
Number of time, no,
the
no.
case, which was originally pending at Bhubaneswar, was being, before this court, being cut on an earlier application for transfer filed before this court by the opposite party wife, being TRPC number 156 of 2020, the proceeding was transferred from Bhubaneswar to Barampur. The present application has been filed by the husband by alleging that despite such transfer of the proceeding from Bhubaneswar to Barampur at her instance, the opposite party wife has not been appearing. So it is alleged that she did not appear on as many as 24 dates. So it is further stated that the opposite party wife is presently posted at Silchar, Guwahati. Silchar in the state of Assam. And therefore, it would be difficult on her part to appear at Barampur. Stop. After hearing learned counsel for the parties, after hearing learned counsel for the petitioner and upon going through the amendments made in the transfer application, this court is not inclined to accept the grounds cited for transfer. For the following reasons. Firstly, only because the opposite party wife is not appearing cannot be a ground to transfer the case back to Bhubaneswar, as it is always open to the petitioner husband to seek necessary direction in this regard from the family court. Secondly, the fact that the opposite party wife is working in the state of Assam cannot give a reason to the petitioner to seek transfer. Stop. It is for the opposite party wife to seek transfer. It is for the opposite party wife to claim to cite difficulty in attendance because of the distance. For the foregoing reasons, therefore, I find no merit in the application for transfer, which is therefore dismissed. It shall, however, be open to the petitioner to appear before the court, Family Judge Barampur, through virtual mode by seeking necessary permission. Stop. If such application is filed seeking permission, the court below shall consider the same in accordance with law. Stop. Further, unless absolutely necessary, the physical attendance of the parties shall not be insisted upon. Yes.
Item number 3.
May I please, Your Worship? I have filed this application for transfer of the civil suit pending the 5th additional Cuttack Mirror to the civil judge Kendrapada. On the regional mirror, the petition, the opposite party number 1 has filed a suit before the civil judge Cuttack Mirror, claiming therein to declaration of a shell deed void as well as for petition. The most of the property are situated at Kendrapada. Only one piece of land that is situated at Cuttack. That has been sold to somebody else, and that has been challenged to be void and separately for petition. No doubt it is maintainable before this Hon'Ble Court mirror. But the convenience of party mirror should be seen mirror because the parties are more than 70 years old mirror. The plaintiff himself is staying at Kendrapada town.
Who is the plaintiff? Petitioner opposite party number 1.
One is a plaintiff.
One now, Umesh Chandra Sahu.
Plaintiff number.
Umesh Chandra Sahu. Yes.
And,
take notice.
And the petitioners number 1 as well as other opposite party, they are the defendants.
You want to take notice on all?
Only one.
On the opposite party. All right. Issue notice on opposite party number 1 by speed post. By speed post fixing a short returnable date. Requisites be filed by tomorrow. Is this matter on 6th May? No, notice on opposite party numbers 2 to 25 is dispensed with for the time being at the risk of the petitioner. Is this matter on
6th May.
6th May. All right.
Further proceeding.
No, you do one thing. You move an application for adjournment. All right. If any application for adjournment is moved on behalf of the petitioner in the court below, the same shall be considered having due regard to the date fixed for hearing of this case.
But the 5th additional civil judge senior division Cuttack.
Court below will call the say order.
Item 4.
Pass over.
All right, pass on.
Item number 5.
May I please? The petitioner challenging the selection process for the post of Jogana Sahayaka without following procedural procedure. So the annexure 1 is the advertisement, and annexure 2 is the selected 32 applicants of.
Where is your name?
That's it.
Where is your name?
His prayer is for consideration of.
No, let me understand. Let me understand. Where is your name in that list? Sir, you list
Durga Prasad Mishra.
Okay.
You means the petitioner.
I am filed, no.
Sir, you are referring to annexure 2.
I am annexure 3. Annexure 3.
Sir, annexure 2 question. Where is your name? Please tell me. Serial number.
Let's see.
ଯାହା ଅବିକା ସେ କହିବେ କୋର୍ଟ ପଚାରିଲେ କହିବେନି
let's say two, serial number
ସେଟା
two.
କହୁନାହାନ୍ତି କି
Two.
serial number 2
And annexure
pursuant of that advertisement
no, serial annexure 2 is the total out of 32 applicants, 20 have selected first round.
Yes.
And annexure 3,
yes
3 numbers of students have
out of
panel.
he was selected
My name is 3, serial number 3,
Namita Pradhan
Namita
yes
Pradhan.
all right then what happened
Let's say in the meantime, I have applied RTA application, and RTA application reveals that the selected candidate have pursued the regular course city course. Now he is continuing city course, and at that same time he is selected and working in the panchayat as Jogan Sayak at the same time.
so your stand is that he did not have the requisite qualification
Like qualification, but misleading the authority. And now continuing regular course, city course, and annexure.
no. What was the requirement of the in the advertisement? What was the requirement? What was the eligibility condition?
And
What is the eligibility condition?
10th pass, and my eligibility condition is the 10th plus and minimum 10th standard. And I have also selected the option number 6 who have selected. He is also selected on the right way.
Saraswati Maharana.
But subsequently she is pursuing a city course, a regular course. At that time, at the same time, he is working as a Jogan Sayak.
That he cannot do.
That cannot do.
That he cannot do.
It deemed to be regular, and work over 10 to 4 p.m. And in the time of
So how does that give you a locus standi to challenge? You are not challenging the selection process. Are you challenging the selection? You are not challenging the. Are you challenging the selection?
Selection, but after subsequently she is working.
So subsequently, if she is working, then it is the headache of the authority. It will become a misconduct. Yes, Mr. Das.
Yes.
How can she challenge it now?
It is better if he brings it to the notice of the authority.
Why? He is a busybody. He is an outsider now.
Yes.
How can he meddle in the affairs of the? How can he?
I am subsequently a selected candidate.
You have been selected. Yes. Please. You are not challenging the selection. Are you? Are you challenging the selection? That is why I am repeatedly asking you from the beginning. Are you challenging the selection?
Selection.
You cannot challenge. You are not challenging.
Let's see.
After being selected, she committed some misconduct. So that is what the authority to decide.
For that instance,
Who are you? Once you are not selected and somebody else is selected, you are out of the process entirely. So you become a busybody. Some complete stranger. I have not raised anything.
I have made.
That
is not my grievance, but I made a grievance before the authority to regarding this.
Representation dispose of karo kichi na khali koidu dispose of karo gote moro disposal moro bodi jibo aguru bodi jibo moro labo kebe mu semti karibi na ya mo na bodu kebe mu karibi representation disposal mu motte karibi na ya. Let me be the poorest disposal judge. I don't mind. But again, please understand. You cannot make out a case here. Unless you say that you are challenging the selection process or the selection of the other person, that's Saraswati Maharana, you have no case. That is why I am repeatedly asking you, why are you insisting upon that qualification or eligibility? That is why I asked you. You have not been able to show me. Because after appointment, she is.
Let's see.
That is for the authority to decide.
My grievance.
This is not a grievance. How are you affected? Supposing some action is taken against her. So how are you benefited? How will you be benefited?
Just selection after she is pursuing.
Yes, true.
But not true. So it's a bona fideness.
Yeah, this court, how can this court be a party to it? Better withdraw it. Think over. I'm giving you some time to. I'm passing it over. Think over what the court has said. Court has not said anything unreasonable. If you look at it very coolly, you will understand what the court is saying. Because I'm not going to simply dispose it off by saying that you consider this representation, because it becomes a judicial order. It becomes a judicial order. And if it is not complied with, a contempt will also lie. So why the concerned officer will be unnecessarily अब देखिए लेट अस सी जेल का अपने गला ये पहले तो उन्नत जेल का समय गला वो योग्यता तथा वेटेज मार्ग से नियुक्ति प्रदान योगान सहायक पद नियुक्ति पाइप सक्सेस जे की नियुक्ति प्रक्रिया आवेदन କରିବା ସମୟରେ ଏହି କଥାଟା ଆପଣ ଯଦି ଚ୍ୟାଲେଞ୍ଜ କରନ୍ତି ତାଙ୍କର ସିଲେକ୍ସନ ଟାକୁ something could have been considered. Consider it. I'm passing it over for some time. I'm passing it over. Go through it. Simply withdraw करो पीछे हो. Yes.
Item number 6.
Well, here I am working as grammar Rojugar Sebab since 2011.
Working as
In view of annex grammar Rojugar Sebab.
grammar Rojugar Sebab.
So, there is a post now. They have created. Government has created accountant comes DO 7,142, and I belong to the district of Kandhamar. For the Kandhamar Miller, there are 184 posts vacant, and for that. I have been recommended, and the eligibility criteria is a grammar Sebako who has completed 5 years continuous service. He is eligible for this.
Where is that?
Then page 15, meticulous. Page 15.
Yes.
Rule 10. A panel list of all eligible GRS shall be maintained at the district level Jilla Parishad, basing upon their date of engagement. Candidates equal to vacancies arising in the area 30% of sanction post, cadres shall be allowed to appear for recruitment through commission. In case suitable candidates are not available, the post shall remain vacant. Provided that, as one-time measure, by way of relaxing the provision of this rule, those GRS who have completed 5 years of continuous service on the date of commencement of this rule shall be observed on regular basis against vacant post of accountant cum data entry operators, subject to fulfillment of other conditions. Then my name has been recommended, Miller.
Your name has been recommended. Where is that?
I'm taking page 25, annex of 5, page 26.
Yes.
It is my name is at the serial number 14, Miller.
But this is not a recommendation.
No, this is my service data, Miller. These service particulars collected from the video, Miller. And video has stated by what are the tenure of service I have rendered under the department. So now, but in the selection list, I am not found. And though no reason is provided as to how I have been dropped.
You had earlier approached this court.
No, Lord, earlier approached for my GRS, Lord. That is also before my law. I was terminated illegally. That I succeeded. Partly, my lord once had it.
So what happened? Where is that improved order?
Improved order is annexed.
So this is 9 list.
9 is the select list.
Select list.
Select list. I am not figured in there.
There are
184 posts are there. I am not figured.
And your juniors have been selected?
Not junior. We are all in different
different places.
Different blocks, Miller.
But there is a clause for maintaining of interstate seniority.
That is there.
Interstate seniority will be maintained as per the gradation of GRS in accordance with rules.
As per their rules, Miller, that will be. But once I am not selected.
No. That is why I am asking the original gradation list of GRS.
That will.
Some people must be senior, some people must be junior to you.
It is throughout the district. Yes.
So that is what I am asking.
Yes.
Have some juniors. All take notice. I think Mr. Das will accept for all.
Yes.
Shri A.R. Das, learned AGA, waives notice on behalf of all opposite parties. 4 extra copies of the writ application be served upon him by within 3 working days. List this matter on Mary. Coded? Which date?
14th May.
14th May. All right. Latest matter on 14th May. What IAD?
One post may be.
Subject to result.
Subject to result. Uh, the order dated 15/3/2024. Bracket annexure 9. Passed by the
Collector.
Come CEO, Zilla Parishad Kondhamar shall be subject to the result of this writ application. Yes.
Item number 7.
My lord, item number 7.
Pass over.
Item number 8.
My lord.
Preferred passover only upon
On the last occasion also you had prayed for thrice the matter had come, you had prayed for the Passover.
Lordship, he is on his legs. Lordship.
I am not bothered by that. This court really cannot consider it. Every time the matter is taken up, you are asking for a Passover. No, probably you are not interested. So I'll dismiss it.
No, Lordship.
I'll just simply dismiss it.
Lordship.
I'm giving you 5 minutes. Call Mr. Rathod. Otherwise, I'm going to dismiss it. Only one Passover. What is this? Every time the matter is called out, you ask for a Passover.
Your ignorance, sincere apologies, Lordship.
Yes.
Item number 9.
My lord, I am a retired lecturer, my lord.
Item 9 is your matter. Item 9.
My name is the consultant, transferred brief.
Acha, transfer. Go ahead. Please place it.
I am a lecturer being superannuated now, aged about more than 70 years in the language. So prior that, as per the career advancement scale, that is a state scale, senior scale and reader scale. The reader scale, due to non-submission of the CCR in time by the principal OP number 3, I am being deprived since 2098.
Notice was issued.
Issued and query was made by this honorable court whether OP number 3. That is nothing today I find. Already.
What is the noting?
OP number 3 principal notice.
As stated, not the letter in original, Principal Dhamnagar College. In continuation of it is informed that the complaint of non-dispute.
Their appearance.
Article has been delivered on 18/6/2011 as reported by Bhadrak DO. It has been delivered. Notice is sufficient. If they are not coming, then what can we do? 2011 matter. Is there any impugned order? I mean, did you apply and which was rejected?
No interim order, only my entitlement.
Against the inaction you have come. Then I can only dispose of, even at this stage of, at this late stage, I can only dispose of by directing them to take a decision. Yes. Nothing further can be done. And on what basis are you saying that because of non-submission of CCRs, your case was not taken up for that higher grade, which is reader scale? You want it from the senior scale to the reader grade? Yes, so what? Where did you apply? Did you approach the authority?
Approach series of last annexed
Annexure 6 probably.
7, annexure 8.
8 man.
Annexure 8, okay.
That is the last.
Can you please place it?
An appeal for personal proof relating non-placement pendency for placement in the grade of reader in English under advancement scheme and to pass order for interest or arrear arising thereof through principal career advancement scheme has not been notified. That for placement in the scale of reader's grade necessary information the duly filled in a new pro forma and a duplicate along with relevant document are submitted to Director Higher Education Orissa.
So there are 3 CCRs of 3 years, 86 to 97. 86, 87 set out. 87, 88 and 89, 90. These 3 CCRs were not forwarded. On account of non-submission of CCR report by the ex-principal agent, the promotion to reader is held up by the higher authority. Copy of notification.
This was sometime in 2010.
Yes, yes.
So let me verify if that was considered and any order has been passed.
All right. In course of hearing, it is brought to the notice of this court that the petitioner had submitted a representation on 12/7/2010 addressed to the Director of Higher Education for grant of for his placement in the reader grade and payment of arrears. It is not forthcoming from the records as to what action was taken on such representation. Then its State Council shall obtain information in this regard from the office of the Director and apprise the court accordingly. List this matter on 6th May. Yes.
Item number 10.
Please write because this is an old matter.
Sir.
So it must come with promptitude. Yes.
Yes.
Item number 10, your lordship, my prayer is dispose of this matter with liberty to approach the appropriate forum. Cause of action survives.
To include the name of the petitioner in the gradation list, common cadre of trained graduate teachers keeping. What are you saying now? What are you submitting?
My lordship, dispose of this matter with liberty to approach the appropriate forum.
Which is the appropriate forum?
If only cause of action survives.
You want to, you have no instruction in this matter now. Yes, sir.
Dispose of this matter with liberty to.
Yes, that order.
If any cause of action survives.
Yes. This is disposed of, Mr. Das.
Sir.
Item 11.
I love that.
And my lord, in this case, I have prepared and also I have filed the death chart.
What are you challenging first? Let us see. What is your
challenging the decision taken by opposite party rejecting my prayer on the ground of no work, no pay.
No work, no.
My lord, may kindly see page 33. Annexure 16 is the informed order which is under challenge.
By the director?
By the directors. Pursuant to order dated so and so, while the Honorable High Court in WPC number so and so disposed of the matter of fixation of pay in matricity post and release of arrear dues in favor of the petition with all consequential benefit with direction to OP number 2 as below. Considering the limited prayer of the petitioner and without going to the merit of the case, this court directs OP number 2 to consider and dispose of the representation if pending before him. This is the order. Then my lord may kindly come to paragraph 1.
Yes.
That the applicant was appointed by the managing committee as untrained Maulavi Madrasa Islamia Sukinda on 20th 1287 and undergone in-service city training during the year 1991. After return from the city training, the petitioner so and so did not report his joining on duties for which the managing committee of the school terminated him from service. Considering the representation of the petitioner and counter reply of the managing committee, the Director Secondary Education Odisha examined the matter and instructed the managing committee by letter dated so and so to allow the applicant to continue against the previous post of Maulavi of the said institution, and further directed that the entitlement of the petitioner as due admissible from that day be released after the rejoining in the institution. The secretary of the school not allowed the petitioner to join there. Accordingly, the director of secondary education Odisha by letter number so and so dated 31/10/2000 adjusted the petitioner against the retirement vacancy of so and so Binjarpur in the district of Jajpur. But the principal of the concerned madrasa did not allow the applicant to join in the said post. My lord, my main case is I was interested to work, but they did not allow me to join. For that reason, I am entitled to get my salary.
Because for you, then my lord come to next page, paragraph 2. While the matter stood thus, the applicant filed a case before Honorable High Court in UGC number so and so with a prayer to allow him to join in any other madrasa in the district of Jajpur and disperse the year salary from 7/11/2000. Pursuant to the order number so and so dated so and so, Honorable High Court passed in the aforesaid OJC with a direction to Inspector of School Jajpur to post the petitioner in other school and take steps to see that the order is carried out. So, my lord, this Honorable Court also passed order in my favor. The Secretary of Madrasa so and so has filed a counter case before the Honorable Court with a prayer not to post the petitioner because villagers, they do not want that I should continue in their village. In the said madrasa, the Honorable High Court in their order dated 15/5/2004 passed in Miss case number so and so, arising out of WPC number so and so, directed the Inspector of Schools Jajpur not to take any action against the managing committee and did not allow the petitioner in the said madrasa, and further directed the inspectors of school Jajpur to take steps for suitable
Repeated orders in your favor.
My lord,
There were repeated orders in your favor.
yes, my lord, all the lecture. If I read all my lord, I am not getting my certificate has not been paid.
Ultimately, when did you join?
2010, after the order passed by this honorable court.
So you are claiming your salary from 93 to 2010.
2010.
Which was which is refused on the ground of no work.
No.
So this is the basic limited thing. So you have to find out what is the position of law.
Because I have annexed all their documents showing that if you are just in somewhere, why you are the authority, you will show how I will join.
Yes, Mr. What is the counter? What is the stand taken by the state?
Well, the stand of the state, my lord, that in fact, my lord, the decision and the directions was to the managing committee. And in fact, my lord, the Jajpur DAO, he has filed a separate counter in this case. And there he has specifically stated that the petitioner had not discharged his duty from 1/4/1993
That's all right, but if you prevent him from discharging his duties, he is armed with an order.
Well, the person who is
He is armed with an order of reinstatement. He is directed to join at a particular place and you don't allow him to join. Then he is again posted at another place. Again, that person does not allow him to join. You keep him out of employment and say that no one.
After going through the same, particularly after going through the averment of the DEO, the Lordship found that the management committee who should have been implicated as a party in this case, an opportunity was given to implicate him as a party in this case because management committee has not been implicated in this case, my lord. So I think it's the government in the today's order, because what the government has been director has been directed to consider the facts, and basing upon the facts, the director came to a conclusion that because for this particular period, the petitioner never
even the absence of managing committee, this decision can be taken because it is challenging, because it all falls back upon the director orders of the order of the director.
Yes, ma'am. But
so the director says that no work, no pay. Once the director says that it is payable, the director can decide which managing committee will pay. It is to be paid by the managing committee. But why should he implement when he is challenging the order of the director? He need not implement. They may be proper party, but they are not necessary party.
But my lord, in the entire averments, entire allegation is against that particular management committee who prevented him to join.
No, but nevertheless, there is an order of the director. He
considers
this directed the director to take a decision.
So take a decision, my lord.
So that decision is now impugned.
My lord, unless and until that particular period for which, my lord, he was prevented or he didn't work, my lord, of his own.
But then the director has passed an order.
Yes, ma'am.
Director has passed an order holding that since he was prevented by the different managing committees.
And prior to this, my lord, also he had approached before this honorable court. And I had I presently, my lord, do not have the briefs, my lord. But if the prayer contains in those petitions also, covering that particular regularizing that period, and that had not been taken into consideration, then in that event, my lord, it is a prospective acceptance of his joining in this case. So, and he has never challenged that one.
No, look, fact remains, you see, what is his prayer? His prayer
to pay the area salary.
No, all right. Annexure 16, which is the order of the director.
Yes, ma'am.
That is the principal player.
Yes, ma'am.
That
Yes, ma'am.
unless you quash it,
Yes, ma'am.
unless that goes, the others are consequential.
Yes, ma'am.
So everything, as I said, comes back to the order, the impugned order,
Yes.
which is Annexure 16.
Yes, ma'am.
The director holds that he is not entitled on the ground of no work, no pay. After himself noting the fact that he was prevented by the managing committee.
Yes.
Is it not contrary to law?
No, well, if your lordship will come to the paragraph.
Let us go to Annexure 16 again.
Yes, ma'am. Paragraph number 1.
এটা তো পড়াই যাইছি আচ্ছা হোক যদি পড়ে পড়ো প্লিজ
না সেইটা সে কয়ে যে মোহাম্মদ মতিউল্লাহ
yes
did not report his joining on duty for which the managing committee of the school terminated his service.
next line পড়ো
Yes, madam. Considering the representation of the petition and counter reply by the managing committee, the director of secondary education Odisha examined the matter and instructed the managing committee by directorate letter dated 20th September 1996 to allow the applicant to continue against the previous post of Molavi of that institution, and for the director that the entitlement of the petition are due and admissible from the date
from that
date to be released after rejoining in the institution. Madam, consider for pausing for a moment, madam. Now, here the claim is from 1993 to 2010. Now, as per the order dated 29/96, a fresh upon joining report is to be given, and he is to be given all the benefits from the date of report.
All right, accepting it from 96.
From 96.
It's 96.
Now, my lord, coming to the 96, my lord,
Yes.
with respect to that particular period. Then, the secretary of the school not allowed the petitioner to join there. Accordingly, the director of secondary education Odisha, by order dated 30th/10/2000, adjusted the petitioner against the retirement vacancy of MCT Urdu in government junior secondary madrasa Binjarpur in the district of Jajpur, but the principal of the concerned madrasa not allowed the applicant to join in the said school due to public litigation.
So he remains from 29/96. He remains outside
Till 2000, madam.
There being an order of the director in 29/1996.
Yes, ma'am.
To resume his duties in his previous post, but with entitlement from that time.
Yes, ma'am.
That is what I understand.
Yes, ma'am.
So that managing committee did not allow him. He was adjusted against some other
Yes,
madrasa. There also he was not allowed.
Then, my lord, he appealed before the honorable court.
Yes.
Then the applicant filed a case before the honorable court in OGC number 5908 of 2001 with a prayer to allow him to join in any other madrasa in the district of Jajpur and to dispose the area salary from 7/11/2000. Then pursuant to the order number 2 dated 26/7/2001 of Honorable High Court passed in the aforesaid OGC with a direction to Inspector of School to post a petitioner in any other school and take steps to see that order is carried out. So here, my lord, another date, my lord, 7/11/2000.
All right.
Then, my lord, the Secretary of Madrasa Islamia, Shukinda Jajpur, has filed a counter case before the Honorable High Court in WPC number 11/827 of 2003 with a prayer not to post the petition in the said madrasa. The Honorable High Court in their order dated 15/5/2004 passed in miscase number 2003 arising out of WPC number directed the Inspector of School Jajpur not to take action against the management committee and did not allow the petitioner in the said madrasa, and further directed the Inspector of School Jajpur to take steps for suitable adjustment of the petition elsewhere. The Honorable High Court in their order number 8 dated 29/9/2010 in WPC number 2003 directed the Director of Secondary Education to take steps for implementation of his own decision in terms of director letter dated 4/6/2010.
Thereafter, I was allowed to join. When this honorable court, division bench of this honorable court directed, you implement in your own order. तुम्हें निजे ऑर्डर करছো तुम्हें लोग को अलाउ करना ज्वाइन करे अपनी
anyway, but how can you claim from 1/4/1993?
Because my lord 93 since then my lord all the annexures I have annexed to my
No. Mr. Tripathi, please come to the previous page. Yeah, one. The Director of Secondary Education Odisha examined the matter and instructed the managing committee by director letter number so dated 20/9/96 to allow the applicant to continue against the previous post of Molavi of the said institution and further directed that the entitlement of the petitioner as due admissible from that date be released. Then when you approach the High Court again on OGC 5908 of 2001, you claimed disbursal of arrears salary from 7/11/2000. So there is another date. But then how did it go in? 93.
My lord, he has committed some.
So even assuming even assuming, yes, so your right of re-employment comes from that director's letter.
Yes,
Correct?
yes.
Now it has to be seen whether the principle of no work, no pay will be, no pay would be applicable to the case of the petitioner, because he has been prevented. And what is this WPC 11827 filed by the Secretary of the Madrasa Islamia?
That filed a case. That is the managing committee has filed a case. Don't allow me to continue in
But
that.
anyway, that was disposed of directly. The director
Yes.
to take a decision.
Yes,
Isn't it?
yes,
So the director has taken a decision.
yes.
We need not go into that case again. Now the director's decision is before us. He simply says, come to the last portion, that despite of aforesaid phenomenon, the petitioner has not performed his duties physically for the period from 1/4/93. We will read it as 29/96 or 24/1996 to 21/12/2010, for which he is not entitled to receive any arrear salary of the period on the principle of no work, no. So how far this is justified? The court will, why will the court go into all other things? Because they are redundant now. They are fait accompli. His initial termination and subsequent reinstatement, or the order of reinstatement.
At least, my lord, I will pray. This matter will be taken up along with WPC number 827 of 2003.
Both the
Yes, so that because there was an interim order
yes,
restricting the petitioners, my lord, to
we'll call for both these both the other cases, huh? Heard and caught. List this matter along with us. List this matter on Kebukuri. 6th May. All right, 6th May. Along with OJC number 5908 of 2001.
Yes, ma'am.
And WPC number 11827 of 2003. Both disposed of cases. Yes.
Item of 12.
From 12 minutes, there was a direction to file an additional affidavit on behalf of the university. That I filed the affidavit. Was,
you have already filed?
Already filed on 14/3/2024 minutes.
Yes.
I'm not solved the copy minutes. I'm serving a copy to my non counsel.
Why didn't you serve copy earlier?
So that in fact I have
unnecessary serving copy.
missing minutes. That is
2012 matter, Mr. Mahapatra.
No, that is.
So you must cooperate. All of you, please. I request.
I've ordered minutes. There is some amount of delay in my part minutes. I put the copy of the
affidavit filed by the university is served upon learned counsel of the petitioner in court, who wants some time to go through the same and to respond. List this matter on?
In India minutes.
29th April.
Item 13.
Madam Jena में
All right, call her.
Item 14.
Item 14 is next week.
Therefore, adjournment is made on behalf of the petitioner. List this matter next week.
Item number 15.
This matter relating to the recruitment to the post of the contract teacher.
Yes. You have not filed a counter?
No counter.
2013.
2013.
Notice was issued and there is an interim order also.
Yes.
The interim order is continuing. Not till the next date.
Not refer division.
Till the next date. Yes, interim order shall continue till the next date. Do you want to file your counter in this case?
If he is insisted, my lord.
Yes, like filed the case, why shall I not insist? But the case is one of the reason. There was an advertisement for 28 and 32 posts. So 50% is the reservation ceiling. But they have only given 3 posts for the UR category. That is why I was kept in the waiting list.
So it comes to what is the percentage?
50%.
Below 50%.
It is much below the 50%.
The counter is necessary. Yes. You have to file a counter within 10 days. I'll grant you 10 days. No further time.
I'll do that.
Not even 11 days.
Yes.
Yes. Learned AG request for some time to file counter. It is seen that this is a case of the year 2013. Notice was issued as far back as on 12/3/2013. as a matter, as last chance. No, one last chance is granted to the state to file counter. This is matter on
9th April.
29th April.
Item 16.
Interim order to continue.
But the ସେ ସିଲେକ୍ସନ ହେଇଥିଲା
Under Sarva Shikha Abhiyan and keeping the core supply. Rehabilitation of the left out NFE teachers.
ଆଜ୍ଞା
You are the non-formal education. ଶିକ୍ଷା କର୍ମୀ.
ଟ୍ରେଣ୍ଡ
ଶିକ୍ଷା କର୍ମୀ ନା କଣ କୁହାଯାଉଥିଲା?
ହଁ ତାକୁ କହୁଥିଲା NFA ମାନେ ଶିକ୍ଷା କର୍ମୀକୁ ଆସିବା ପାଇଁ ସ୍କୋପ ଥିଲା.
ହଁ ହଁ ହଁ.
His claim is that he was never adjusted. She was never adjusted.
page 27 ରେ
Is it not too late in the day to reopen this matter? Oh, you had come in 2013. That is true.
ମାନେ ସେଇ ଗୋଟେ ମାନେ ମୁଁ
What order can be passed?
ରାଇଟ୍ ଏକ୍ସରସାଇଜ କରିନି ଗୋଟେ ଅର୍ଡର ହେଇଥିଲା ମୋ ନାଁଟା ଥିଲା ପେଜ
But what order can be passed now?
ମୁଁ ଚାହୁଁଛି ମାନେ ପେଜ 27 ଖାଲି ଟିକେ ମୁଁ ବେଶୀ ମାନେ ଆଇ ଏମ୍ ନଟ୍ ଏକ୍ସରସାଇଜିଂ ଦ ରାଇଟ୍ ଖାଲି ପେଜ 27
The proposal submitted by you.
ମୋ ନାଁଟା ଥିଲା 24 ସିରିଏଲ ନମ୍ବର 24
Data କଣ ଆଗେ ଟିକେ for appointment of non-formal facilitators as government primary school teachers are hereby approved subject to the conditions stipulated. So where is your name?
page 27 serial number 24
Serial number 24.
ସେବତୀ କର
Who page?
page 27 of my edit petition serial number 24
ସେବତୀ କର. Yes.
ସେବତୀ କର ହଁ ମୋ ନାଁଟା ପଠେଇଥିଲେ ଇନ୍ସପେକ୍ଟର ସ୍କୁଲସ୍ କିନ୍ତୁ ଫର ଦ ରିଜନ ନୋନ୍ ଟୁ ଦେମ୍ I was not adjusted given upon. ତାର ବର୍ତ୍ତମାନ ତ ଆସିଗଲା ମାଇଲର ଏନସିଟି କଲା ପରେ ଯୋଉ ଏଲିମେଣ୍ଟ ଟିଚର ମାନଙ୍କର ଯୋଉ ଓଟିଟି ଫୁଟିସ ଆସିଗଲା ତେଣୁ ମୁଁ ଆଉ ଏଥିରେ ଆଇ ପ୍ରେ ସେ ଯୋଉ 30/6/15 ଅନୁସାରେ ଯଦି କଲେକ୍ଟର ଡିସାଇଡ ବିକଜ ଚେୟାରମ୍ୟାନ ଅଫ ଦ ଏସଏସଏ
What can he decide now? What can he decide? The entire law, the entire requirement has changed.
I think, my lord, the entire thing has already been decided. This petitioner, my lord, previously she had approached before the London Tribunal in ON number 665 of 2011, in another ON number, my lord, of 114C of 2013, and there, my lord, some orders were passed and the order was implemented. But he has not disclosed anything.
ନା ମୁଁ ଲେଖିଯିବା ମତେ ସେ ଆନେକ୍ସର ସି ବାଇ 4 ମାନେ ମୁଁ ଖାଲି ପ୍ରେ କରୁଛି ଯେହେତୁ କଲେକ୍ଟର ଲେଖିଲେ ଯେ 24 eligible ex NFE persons had been observed as a primary school teacher 24 ମୋ ସିରିଏଲ ନମ୍ବର 24 ମୁଁ ମତେ ନ ଦେଇକି ଦେଲେ ତେଣୁ ମୁଁ ଡିଷ୍ଟର୍ବ କରିବା ପାଇଁ ଚାହୁଁନି ତେଣୁ ଆଇ ମେ ଲିବର୍ଟି ବି ଗିଭେନ୍ ଟୁ ଆପ୍ରୋଚ୍ ଦି କଲେକ୍ଟର ସେ ତାଙ୍କ ଯାହା କରିବେ ସେତିକି ଆଉ କିଛି ନାହିଁ ମୁଁ
You had a right. At the relevant time, you had a right.
Yes, right.
Mr. Nadi, 11 years have passed. And within this 11 years, there have been serious changes in the elementary education. And the new act has also come.
ଆସିଗଲାଣି ନ୍ୟୁ ଆକ୍ଟ ଆସିଲାଣି ତେଣୁ ଏବେ ସେ କିଛି କିଛି ଗଣଶିକ୍ଷକରେ ଦେଇ ଦଉଛନ୍ତି ଗଭର୍ଣ୍ଣମେଣ୍ଟକୁ ପଇସା ନେଇକି ଦେଇ ଦଉଛନ୍ତି ଏବେ ଟ୍ରେଣ୍ଡ ଆମେ ସବୁ ଟ୍ରେଣ୍ଡ ମୁଁ ସିରିଏଲ 24 ରେ ଯେହେତୁ ମୋ ନାଁଟା ଅଛି ସେ 24 ରେ ଦେଇଛନ୍ତି 20 ମୁଁ 25 ରେ ପାଇବା କଥା 25 ଟା 24 ପାଇଗଲା ତେଣୁ ମୁଁ ଆଇ ୱାଜ ଡିସ୍କ୍ରିମିନେଟେଡ୍ ତେଣୁ ଆଉ
As I said, you had a
without reopening I may approach the collector.
Yes. What do you say?
Yes.
The petitioner has approached this court seeking the following relief. The limited grievance of the petitioner is that she was engaged as non-formal
instructor,
non-formal education instructor. Instructor. Way back in the year 1997. 91 were they?
No, you must come 91. 97.
No, 91.
So, a question I can have.
We were disengaged also.
Disengaged. That's much is a universal disengagement. Into each of page 27
upon cessation of the non-formal education scheme, all such instructors were disengaged, including the petitioner, by order dated 31/3/2001. Subsequently, on the basis of a decision taken by the government, where is that letter you are referring to?
On page 27. List select list.
Decision. a decision was taken, subsequently, a decision was taken by the government to appoint said non-formal facilitators slash supervisors as government primary school teachers.
Those who are trained. I'm a trainer.
Who have training qualifications.
Yes.
Stop. By letter dated 2/8/1997, the inspector of schools forwarded names of such persons to the director. No, to the inspector of schools, forwarded to the director, the district inspector of schools.
I guess.
To the district inspector of schools. Cut off. The inspector of schools. The inspector approved the list of several such instructors, of which the petitioner claims to be placed at serial number 20. It is her grievance that despite such approval of her name, she was not given the benefit of appointment as government primary school teacher, whereas other persons in the list were so appointed. The petitioner claims to have submitted several representations at different times to the Commissioner cum Secretary of the School and Mass Education Department for consideration. It is submitted that no action has been taken on such representations even till date. Stop. Having this court therefore does not find it prudent, does not consider it prudent to keep the writ application pending any further. The writ application is therefore disposed of, granting liberty to the petitioner to submit a fresh representation. To the secretary department, to the government in School and Mass Education Department within a month, highlighting her grievances. If such representation is submitted, the same shall be considered and disposed of in accordance with law within a further period of 8 weeks. Stop. The commissioner shall grant an opportunity of personal hearing to the petitioner before disposal of such representation. Yes. Right.
Item 17.
In that case, I am appearing to Union India. I want 1 week time. My name did not appear in the list. I could not file. Let it come next week. This is case of whether the age can be enhanced to 65 as retirement date in case of Sanskrit Sansthan.
And you are appearing for
Union of India.
for the petitioner. All right. As prayed for, list this matter. On 29th April?
Fine.
Item number 18.
It is a case. I paid for my arrear salary as a on-time teacher as well as a salary in the trained scale after I became trained. His services were terminated when the institution was unaided. Filed an appeal and on the direction of the appellate authority, that the regional directive was reinstated. Order could not be complied. But later on, by the interference of this honorable court direction, then he was allowed to join back in the duty. Thereafter, he was not paid gratuity because at the relevant time he was on track. So again, I have approached the tribunal. In the tribunal, I have succeeded. Tribunal has directed him that he is to get the benefit of on-trend scale of pay, keeping in view the judgments of the High Court. The case was challenged in FAO. FAO was also dismissed. I have filed a writ petition also for implementation of the order of the tribunal. By virtue of that order, they have implemented the order, allowing me the on-trend scale of pay. So now only thing remains is now the on-trend scale I have to get till I attend the training qualification, and after I became a trained person, I have to get the training scale. This is my simple reply. A voluminous counter affidavit was filed, and last occasion they have served me. I didn't feel ki no reply is required. What you want to say now, the DO, you want to question the order of the regional director, the appellate authority, his own authority. Thereafter, he also want to challenge the order of the tribunal, which has been upheld by this court. He says everything is wrong. His appointment is administered. I don't think this type of counter will be acceptable if my lord will allow me to file a reply. Also, I don't want to file a reply because this is the only statement. He has not stated.
Then give a reply for whatever work you have to give a reply.
Only this.
No, I'm ready to hear. If you.
No, because with this fact, admitted fact, he is also admitting. He is annexing these orders.
All right, then place it. Let us hear it.
My lord.
Let us hear it finally.
Yes, he has given the order of the tribunal, kind place 30 of the counter. Let us not waste time. Page 30 of his counter. Order of the tribunal. What I have taken, he is relying upon. But he is saying everything is wrong because of some other judgment which is not decided in this particular. 30, my lord. That counter.
Yes.
That is the order of the tribunal. Filed by me.
Is it a part of an annexure?
Yes.
What is that annexure? Please tell me.
It is annexure I. But I will have a glance.
So there is no.
This is the hard copy.
The annexure G.
G का I तो लिखा है.
I have handed over. But you refer to the annexure because the page numbers are not right. This is the judgment of the tribunal.
My lord.
All right, sure.
Can you see that? I have given that order.
No, it's not sure. Yeah. The same order.
Same order.
I think it's not.
This I have filed in the tribunal. Now kindly see what is the order. Final order. The court has directed. Order is page 34. The case is allowed on contest, but without cost. Annexure 5 is quashed, where my approval was declined. OP 1, 2, 3. State authorities shall approve the appointment of the applicant and shall give him the grantinate at on-trend scale within a period of 3 months from the date of communication. This is the order. And virtually they have approved me and paid me the on-trend scale. So now it has been implemented. So only thing in the meantime, I have acquired the qualification, training qualification from the IGNOU, which is also acceptable certificate. In the counter, what he said, you could not qualify for selection as a BEd to the BEd training of the state government. So if you have obtained IGNOU, it will not be acceptable because you are disqualified for selection. This is a very peculiar counter, and my approval order, my lord, can have a glance. He has already approved it. Annexure 1, page 10. By referring to that JIS and also consequential High Court order, he has approved my service. The same officer, now he has filed the counter. Subsequent page 12, he has allowed me the benefit, that enhanced benefit of a particular scale of 40%, 4,500.
On-trend teacher against TGT post for the management is hereby accorded. This is the on-trend scale.
On-trend, yes, because by that time I only became trained in 2014.
Yes.
This is in 2010.
So now you are claiming again on-trend from which period?
Yes, well, what happened on-trend, I have not been paid, though I have been reinstated. I am to get it from the date I am entitled to, the institution, because I was terminated and I was prevented by them. So I am to get it from other staff, what they have got it from 1/1/2004 to 28/6/2010. He has paid me from 29/6/2010. After the tribunal's order, after the High Court interfere, only he has given it from the date.
No, where is that order of reinstatement by the tribunal?
The tribunal only after the
Tribunal or the director?
Director order, I have approached this honorable court. When I have approached this honorable court, they didn't do anything.
Where is that order of director? Do you have?
Director, they in that because this is admitted fact, I have not.
No, it may be admitted, but I would like to see what was the import of that direction, because whether backwages was,
Just times.
it was a case of reinstatement, with or without backwages, that has to be seen.
1 minute.
Your right flows from the order of
The director.
Yes.
Yes, it is the order. Just reading out and pass on, my lord.
Yes.
In the earlier, I have perused the record, heard the parties, and have gone through the decision of the Honorable High Court. So to me, from the record, it is seen that the MC has got and not given reasonable opportunity to the appellant before terminated. No proof is filed to show there was service of notice so caused to the appellant. No inquiry whatever conducted to prove against the petitioner appellant as required under the law. Hence, on my considered opinion, there is a violation of natural justice, and thereby the order of termination service of the appellant is set aside and is directed that the MC and the headmaster of the school shall allow the appellant to work in his former post. The next question is to, for consideration, is to send the appellant for beer training as an in-service candidate. In view of the decision of the Honorable High Court in the case of Vivekananda Das versus State of Odisha, reported in 1997, 2LR, phase 122, and the judgment dated 11/3/2002 in OJC 10216 of 2001, and the batch of cases, I am of opinion that since the appellant is deemed to be in service after the termination order is set aside, he shall be sent for beer training as an in-service candidate. The Inspector School, Mayurvanj Circle, is directed to forward the applicant from the applicant for the selection to the B.Ed course next session 2003. This was the order. So there is no that I will get it from the reinstatement. I am deemed to be in service. My termination, so I am to get the benefits. So I want that since all other employees of the institution got it from 1/1/2004. So I should be given it from that date. What he has done, he has given it from the date. After this order of the director is.
Yeah, but can you read it in isolation? Admittedly, he was an untrained.
Yes, ma'am.
He was working from 2004.
Yes, ma'am.
2004.
No, I am appointed in 92.
So why did you say that 2004?
No, 2004, my lord, institutional payment to 4 granted.
Granted it. So it was directed that those people without training will also get the untrained skill.
We have also made our specific stand, my lord, in the counter. The reason why he should not get it, we have narrated, my lord, in our own way, my lord. But
let us see.
so, but the thing is that, my lord, Annexure 1, my lord, I placed it, that it is from a prospective date, which is not under challenge. Annexure 2 is also, my lord, identical to that one, which has been made subject to final outcome of the FAO number 6 of 2007, pending in the Honorable High Court, my lord. And there also, my lord, it has been mentioned that see, Ajit Kumar Mishra is hereby allowed block grant at the rate of 60%, also in the on-trend scale of pay, plus dearness allowance, basing upon such pay with effect from the date of his joining from 29/6/2010, as per Odisha Education Payment of GIA to High School Order 2004, issued by Order 8/12/2008 in the Department of School Master Education. It is also repeated, my lord, on the date of joining. Then, my lord, Annexure 3. He submitted his B.Ed certificate. 10/14, my lord. And on the basis of the same, he also made a request to receive the trend scale, what he deserves, in 2014, my lord. According to these documents which he is relying upon, my lord. My lord, the prayer in the present writ petition is not contrary to those documents. And if such documents have been accepted and that have not been disputed, a prayer claiming the benefits prior to those dates, my lord, that amounts to change the conditions, whatever it is available in Annexure 1 and 2, my lord, which he had not referred to. And we have made it clear in our counter, my lord. Other than that, the claim what he has paid for with respect to that grantee net and on-trend against an additional section teacher post. These things, my lord, which we have clarified in our counter, my lord, it is.
Additional section is the regular staff, not additional section.
Sir, you prefer not to challenge the, not to.
Oh, yes, I will.
This is the statement I have made in my
I will have the answer
counter.
to that. I will see.
So.
Then additional section here, that is actual.
It is actually after relying upon the documents, my lord, the para number 15, my lord, of our counter, which starts from page number 13 onwards, my lord. We have given a point as reply that why is not to be entitled with that particular benefit.
Para 15.
Para 15 onwards, my lord. The claim advanced by the petitioner, that is in page number 14, my lord, this of para. Are not admissible at this stage in the framework of the law and rules to be law that we have indicated, my lord. So he prefers not to dispute the same, my lord. He has also not challenged Annexure 1 and 2, the conditions stipulated therein.
We continue again tomorrow.
Well,
Jete kali ketara achi pattern kiri. Nahi.
So the data part.
Dita pattern. Certain part is this matter tomorrow. Ketara achi kyo?
ये तो सब subject है।
Totally. Because I just list করছি আর কত হবে না। ঠিক আছে। Password act.
So जो वन पास होते हैं सब होते हैं सब मतलब जो वन पास होते हैं so that
So item number 8.
item 7.
7 number. 7 টা কোন পাস ওভার দিলা? I will take it up. I'll take it. This was passed over on the condition that I will call out within 1 or 2 days. Matters.
Oh, good.
Yes. This is the matter, my lord. Where my lord see the additional affidavit filed by the government. The special officer for the moment, the only reason, my lord, they have assigned affidavit filed on 30th of March, my lord. Yes, para 8, my lord, thanks. Para 8. Case of the state opposite party that due to government letter 22/2/21, the salary of the petition has been stopped until further orders, though the said order of the government letter 22/20/21 was challenged by the petitioner in double basis so and so, but the same has not been considered by the Honorable Court to file disposing the writ application. Now, my lord, the only consideration of the round, my lord, they have said that only because of the letter dated 22/2/21, my salary has been stopped. That document, my lord, kindly see for a moment, my lord, annexure C/5 to the affidavit filed on 21st of November 2023. Though subsequently, my lord, new statement was given that with regard to handing over charges and everything, but the only reason, my lord, for not releasing my salary according to the state, my lord, because of the letter dated 22/2/2021, annexure C/5, my lord. Because of this letter, my lord. But kindly see the order, my lord. This is a letter issued by the Joint Secretary to Government to the Principal Governing Body, my lord, on the basis of a report. Kindly see report is page 19, my lord. An inquiry was conducted on the basis of allegation of that one villagers as well as the Honorable MLA. Inquiry was conducted by the Regional Director, and on the basis of that inquiry on 22/2/2021, an order was passed by the Secretary, Joint Secretary to the President of the Governing Body to take all these decisions, my lord. My respectful submission, my lord, as per 1974 rules, the being petitioner is an employee of an aided institution and approved employee, my lord. The governing body is the disciplinary authority. Governing body has not made any inquiry. No notice, nothing was done by the governing body. An inquiry was conducted by the regional director. On the basis of said inquiry, a letter was issued by the joint secretary to the president governing body. My subsequent submission, my lord, on the basis of letter dated 22/2/2021, no order was passed by the president governing body, the so-called president, or by the governing body to against petitioner with regard to stoppage of salary. This is, my lord, kindly see the letter dated 22/2/2021. Pursuant to that, my lord, an order was passed in 2022. If my lord you got it, page 42, it may to the writ application. As I find, this is that where there was a dispute relating to handing over charge. See, subsequently, what has happened is, what I find is that this entire thing has become a mess. It has become unduly complicated. So, say subsequently handing over this filing of affidavits, counter affidavits, and rejoinders, further affidavits. This has complicated the entire issue. That is why I place para 8, my lord. The reason for non-release of my salary, they have stated. My only prayer is application for release of my salary. I know what I will do. In view of the direction of yes, I would like the assistance of the state in this regard, because it is your counter. Now, she claims, let us compare prayer first. Forget about every affidavit. I see this is like a, you Golokadanda Kundani, Golokadanda
proceeding, my lord. This is a case which has been specially assigned to Mr. Sangram Jana. But since he's going to reject, but I will see it. Yes. I will not wait. No, yes, ma'am. I am prepared, my lord. Sorry, no, I'm prepared. Last try on 3 occasions your associate is asking for a passover. Sorry, my lord. I think, my lord, I'm going to close it today. I will simply direct the commissioner come secretary to take a decision. Who is going to enter? This writ court will enter into all these factual aspects. My lord, today a stand has been taken. Rightly, he has pointed out. The stand has been taken in paragraph 8 of the additional additional affidavit. So now, according to your lordship's direction, my lord, on 10/4/2024, yes, one instruction has been received from the office of the ADM Noagar, Commercial Officer. Yeah, that taking over charge. Now, how can the court decide? Exactly. Better it will be. How can the court decide? Tell me. So it all falls back upon the question whether he had actually physically handed over charge or not. They are holding it back on the ground that she had not handed over charge. Your salary from February to June, that is being held up. You are claiming that, my lord. That 4 months, 4 months salary was held up on the ground that she had not handed over charge. No, on the ground because of the inquiry, my lord. Subsequently, they are saying, my lord. Subsequently, they are saying that because the initial on the ground that so there are two reasons. One is, let us accept you did not hand over charge. Second is there was some inquiry. So charge hand over no, they can take any decision subject because the document file because that is a question for decided by the commissioner whether he has handed over or not. Decided said by my lord. But so far as my release of salary, government release I am an approved staff. Government has already disbursed my salary. But the person, AP5 is not releasing my salary on the reason I have best known to him. Because I am an approved staff, principal has already, government has already disbursed my granting aid, but they are not releasing salary of others. I approach the summary court only on the ground of my annexes CY5 because of inquiry 2021, my lord. 2021, there is no direction to stop a salary. They said you take any decision. They say you issue show cause notice. Thereafter, no show cause, no decision. Rather, page 42 kindly see. Rather, they decided to remove me from the post of principal, which are challenged subsequent request. कौन सी decision नहीं ना ठीक है तो stoppage of my salary. Retirement to पूर्व दिन से कौन सी जगह because of this inquiry of 2021, your salary was stopped, my lord. I retired in July 2020. Inquiry was made in 2021. They passed over 22 page 42. I can see. So, your according to you, the government has released the salary. Government released also. Same होना नहीं. 2 मास खाली बिल पठे ना दी बाकी 3 मास गवर्नमेंट रिलीज कर दीच. लास्ट 2 मास बिल टा पठे ना दी जो आपण इंट्री मॉडल में पाइली गोटे मास आ 2 मास बिल पठे देनी से जान की आ 3 मास बिल पठा हितला मोर पैसा आसी छि कि मतो ना. Yes, what do you say? This is a purely factual aspect. Yes, factual dispute. Let the enter matter make please because the commissioner secretary, opposite button 1.
You have to articulate, you have to crystallize the points so that it will be easier for her to take easier for the authority to take a decision. Because I find normally I would have directed the director to take a decision, but here even there is an order of the director also, isn't it? What further can he do? Otherwise, this will be entering into a labyrinth of counter, additional counter, pleadings, multiple pleadings. Nothing will happen. And the person is, if she is entitled to her salary, she should not be deprived. Yes, that's all. Yes. And where is the original prayer? Prayer number page 29. Release the area salary petitioner from the month of February 20. Yes, that is what I remember it. Yes, February. So basically, there are two things that they are saying. One is that there is some inquiry against you. Inquiry has not been initiated. No inquiry by disciplinary authority. The inquiry by the RD. According to them, the inquiry was made, direction was given. My submission, my lord, there is no inquiry by the disciplinary authority, no decision has been disciplinary authority. RD communicated letter to the P1 commissioner. Commissioner passed a letter to the president, the so-called president. President passed another, you remove him from the court of principal. That was challenge, that was quashed. No decision with regard to stoppage of my salary. Even by the original director or the P1, my lord. Till date, my lord. Yes, Mr. Patak. Yes, sir. If we direct the commissioner, yes, because as I have been repeatedly saying that there are two pleas taken by the opposite parties. One is that there was some inquiry which has not seen the light of the day, yes, and second is she did not hand over charge. Isn't it? Yes, ma'am. These are the two things. So let her consider. Let her consider. Or let all the parties be given an opportunity of hearing. Let them produce the documents. Let her take a decision. Yes. Then that decision can be subject matter of time. Within a stipulated time for them. The petitioner has approached this court seeking to follow the legal. Bereft of unnecessary details, the case of the petitioner is that her salary for the period from February 2023 till June 2023 was not released. Stop. She retired in the month of July 2023 on attaining the age of superannuation. It has been stated that because of an inquiry proposed to be conducted against her on the ground of alleged misappropriation of some amount of the school funds, as also for non-handing over of the charge of principal to her successor, her salary has been withheld. Stop. This court finds from the pleadings of the parties that this is basically a factual dispute which requires resolution by the concerned authority after hearing all necessary parties and upon going through the relevant records and documents. Therefore, without expressing any opinion on the merits of the case, the writ application is disposed of, directing the secretary, is a party, secretary to the government in Department of Higher Education to himself conduct an inquiry, to himself inquire into the matter and to take a decision with regard to the demands of the petitioner after hearing all necessary parties and after hearing all necessary parties. Stop. The entire exercise shall be completed within a period of 4 months. You must election to police. Because of the election, otherwise I would have granted 2 months.
Sanction is
It goes without saying that it shall be open to the petitioner to claim release of her current salary, the salary which is said to have been sanctioned
government.
in her favor by the government. Stop. If such application is, if such prayer is made, comma, the secretary shall also consider the same pending disposal of the inquiry. I have disposal.
Sorry, madam.
I think I am sorry now. My lord, interim stay to be vacant. Wait, it is stay of like second to be joined.
Case sorry,
You were never appearing and Mr. Author is never appearing.
sorry, my lord.
So today I was determined that I will conclude this case. I will conclude it. Sorry, तो current secretary को बाकी जाकर एकता करिए. What is the sub item? We'll go to the sub item now.
The instruction that last time the objection.
No, I will not get into all those things unnecessarily. What is the next matter, Mr. Author?
Challenging the approval of the.
Never got any relation with this?
এটা স্যার রেফারেন্স পাই আপনি আনিছিলে এটা যেহেতু ডিফরেন্ট কোর্টে আপনার রেফারেন্স আলিগেশন ଥିଲା যে অল ম্যাটররা ফাইল ହେଇଥିଲା without
I'll release it.
সেটা
No, instructor saying for that court to decide. I cannot pass that on.
She is a retired person.
He is a retired person now. Sir, it is not within my assignment. Can I take note of or can I pass any order in this? I had called for reference.
reference master.
So this is of which year? 2022.
Yeah.
How can I hear that matter? Only for reference I had called. Let's this matter before the assignment.
ସବୁ
Again, sir.
ସବୁ ରେଫରେନ୍ସ
Yes.
এইটা লিস্ট
Yes. Item number 19. Item 19.
This application I've challenged order dated 2016 as by the next rate by the collector. Holding the disengagement order dated 14/1/2005-15, which was passed by the Son of Court in earlier read application.
Pleadings are complete.
Pleadings are complete.
So you are challenging the order of the
collector and had annexed right. I prepared.
Annexed right.
Notes on dates, my lord. That will be.
Just a moment. Disengagement.
Notes on dates.
Oh, thank you.
So petitioner has been disengaged from the post of Shikha under the provisions of RTE Act due to engaging of 17 children of his school for plucking cotton from his own field. Very interesting.
Without dates.
For at least 3 days till they were rescued by the CWC.
And his own,
So he has taken evidence also.
yes. His grievance is that, my lord, since on the self-same allegation, a criminal proceeding was instituted and there was after the discharge petition submitted by the petitioner was a Indian items allowed. Therefore, this case is to be allowed in his favor.
No, the criminal case, discharging the criminal case will have a.
My submission is completed. The criminal case, the basis on which, my lord, he has been discharged. If your lordship will go through that order, that has absolutely no bearing in this particular case because here sufficient evidences are there and that has been taken to consider.
What is the decision? Captain M. Paul Anthony.
M. Paul Anthony.
Yes. And Janaki Raman also has probably discussed a little bit about the effect of simultaneous of this criminal proceeding and the
GM Tonk, my lord. GM Tonk.
Yes. The Gujarat case.
My lord,
That, my lord,
That is the leading discharge.
But here, my lord, the.
Let us see the order of discharge. The
Yes.
criminal petition.
My lord, I'll.
They have.
Yes. Let us understand, then I will ask you.
Okay.
It will be easier for me if I understand the case.
It is,
For me, I do not read the brief earlier. I do not carry, my brief doesn't go to my home. So I am doing it for the first time. If I understand it basically, then I can understand your break chart.
I know.
Where is that?
my lord, it is additional affidavit filed by the petitioner.
Annex 8, my lord.
Additional affidavit, yes, Annex 10 is the order of
Annex
discharge.
8, my lord. Annex 8, page 39.
So it appears that the occurrence took place and the matter was reported and the inspector himself took time to investigate. So he says that the prosecution report was submitted after almost 1 year of the occurrence. There is no, is there any limitation here?
30 days, my lord. Under that, that is
That
30 days.
it has been-
He has to some, CWC has to.
So this cannot be treated as an honorable discharge. Honorable acquittal of G Tankre, I think that order is there.
But
You can claim protection or you can claim that the that having been discharged in the criminal case, the disciplinary action no longer should be, held against you. You can take that stand only if the acquittal is honorable. Honorable acquittal. After going through the evidence and everything, the court finds that no case is made out against you and you are acquitted, then only that will help you.
My lord, prior to discharge order, this order has been passed.
What discharge order?
Prior
is-
to
this is order of discharge.
criminal proceeding, this order was passed.
the disengagement order was
Disengagement order was passed, but
Disengagement order was passed earlier and it was approved by the
later
collector.
on this.
Yes.
Later on, I will discharge.
Now on the change facts and circumstances, he wants to say that, my lord, this is the
No.
circumstance. and-
Only that point, I'm not saying that only that point. I've also, before that also, I have challenged in deed application and other points also.
Now the collector's order is wrong. Now the problem is the collector has taken evidence and basing on the evidence, he has passed an order.
No, well, that's what I'm saying. They are confused whether it's on 12/1/15 or 13/1/15. They're not sure. CW said that they were submitted 13/1.
All right, come to your
Come to your
date chart.
That's it. When 3/12/2010, I've been engaged as a CASOI. Then 28/6/2010, I took training. Then I qualified in training. Then 28/2000, the petition filed writ application for regulation fixation my lord. Considering the length of service which are disposed of on 17/5/12 by this court directing the opposite party number 1 to consider the representation under the answer to the writ petition within 6 weeks. Then my lord, 17/6/2000, pursuant to the agreement that what office order number was passed, posting the petition at Matigonas, my lords. Annex 3. Then my lord, a complaint was lodged by child helping, alleging that the petition has committed criminal act by engaging 70 students for plucking cotton in his field at Bakurguda, 8 kilometers from the school. Then my lord, 13/1/20, BO Diagra deputed ABO to conduct an inquiry, and accordingly ABDO conducted an inquiry and submitted report on 13/1/2015 stating that the allegations are true. Then my lord, 14/1/2000, on the basis of an inquiry report, order of engagement was passed by the Disengagement order passed by the Rayagada, Collector Rayagada. Then 18/1, the parents and guardians of students submitted repeatedly repeating the allegations. Annex 1. Then 16/9, challenging the order of disengagement filed WPC number, I think, which was disposed of on 16/10/2015, quashing the order of disengagement order dated 14/1/2015 and remanded the matter to the collector Rayagada to take a fresh decision in accordance with law. Then 21/2000, the Assistant Labour Commission Rayagada has issued a so-called notice to petition as to why legal action shall not be taken in violation of Section 9(2) of the Child Labour Protection Regulation Act, Annex 9. Then petition submitted to reply to that. Then 2/11/2020, the petition submitted repentance enclosing the certified copy of the order, passing WPC, stating that the order has been quashed, so I may be appointed. Then 13 prosecution report was submitted by the DLO Rayagada in the court of the land Rayagada, which was registered and so and so. That is additional affidavit I filed. Then 23/2016, collector comes your Rayagada passed the impute order under the next 8 at page 39 to 42, holding that the order of disengagement passed is justified, which requires no interpretations, even though the same was passed in earlier petition. Then, my lord, 2008, pursuant to discharge petition filed by the petition, the matter was taken up for hearing on the point of charge. The land court below held that there is no prima facie matter to proceed against the accused. According to the petition filed was allowed and petition was
discharged.
My lord.
So in this background, we are challenging the order of the collector.
My lord.
Where is that order?
Order is annexure 8, page 30.
Annexure 8, yes. The petition was deposed on oath. So unless you show that there's something very seriously wrong, this is a certiorari matter. Why should the court interfere? Because he has taken evidence.
No, that is what I'm saying, my lord. They are not sure. When the collector order, inquiry order, you will find out. So, they say 12 and 30.
No. What is the mistake here? Please tell me. What is wrong in this order?
Lord. My lord, here, para first minor, the effect of the case minor. So,
Yes, it is okay. You come to the
guaranteed to under RT Act and as for clause 11.
Where are you reading from?
First, page 39, first para. The case interpreted, then the next para. The effect of the case. Towards the last portion, I'm reading, my lord.
Yes.
It is better. Deliberate gross violation of the right to education of children guaranteed to them under RT Act 2000 and as for clause 11 of the terms and conditions of the contract agreement. But as for the contract of the terms of contract, as mentioned, I have not violated. It's not correct. Then, my lord, this is I'm not reading para 2. Then I'm coming. I know. My lord, page 40, second para. On the date of hearing, the petitioner is deposed on oath that during allegation of 17 student engagement at Cotton Field, he was the Shiksha Soyak at Matigona PUFs. He had told to the parents of the said students to go to the festival in his own village, Bakrigoda. He had told them to go for the festival during school time also. He had not told the students to go for cotton. Then, my lord, it is patent mentioned that the petitioner has been discharged from the post of cemetery school. Next para, next month. In this deposition, Lakshman ABO, Rayagada, stated that he was ABO while he inquired into the case of Baburav Himirka. He inquired into the case as for the children of BO on 13/1/2015. As for the inquiry, Baburav Himirka was working at Matigona Piers. He inquired from Baburav, who had told that he had called 17 students to village Bakura. During recording the statement by ABO, it transpired that Baburav had asked the student to ask their parents to meet him if they require work. Going through the entire documents available on record, my finding. Going through the entire records available on the record. It transpires from the inquiry report dated 13 by ABO Rayagada submitted to the BO Rayagada that Baburav Himirka Shiksha Soyak Medical PS had utilized 70 students of the school in his cotton field as per the statement obtained by ABO Rayagada in presence of CRCC data. Item number 1. Why your school students 17 numbers in different classes were engaged by in your cotton field? Reply. Mr. Baburav has informed that the petitioner he neither asked the students to engage in his cotton plucking in the field nor brought them to his farm. Then, my lord, if not informed to them why they had been to your cotton farm during the visit of Child Welfare Committee. In the above facts, he stated that he never identified to his farm to these students, but invited them to their village festival named by Cattle Puja at Bakrigoda. Then 2 days back, he informed them to engage by their parents as number of plucking cotton. Then he confessed his word to them, informed the students for the purpose. So, it is also verified from the attendance sheet of the 70 students.
submitted by the ABO, and she has said that these students reading within classrooms were remaining absent for several days within the period of 5 to 13 months. That inquiry report and attendance sheet is also correct, but this is not correct. That is also I filed in the writ application. It is pertinent to mention here that cotton field of Babra Vilkas from the present, and these students are rescued by child line on 12/15. Here they say 12/15. But
what is wrong here? What is wrong?
I have not never engaged my lord the students.
But that is a finding of fact. He has found that.
That's not finding my lord.
Well, what is wrong in his finding? Tell me. So that is what I'm saying.
That is what saying, my lord. I have not asked the students to go there. I have not have any cotton field in my name. I don't have land, my lord. Nothing has been inquired.
So why didn't you say that before the collector? You have never said that you had no cotton field, nothing. Rather, you say that you invited them to your village festival.
Parents, my lord, because Makar Sankranti and Adivasis, there's a festival.
That's all. You never said that you don't have a cotton festival. What you are saying before this court has not been stated by you before the collector. You are raising it for the first time.
No,
the collector makes a factual inquiry, records your deposition as well as the deposition of the ABO, and on that basis arrives at a finding. Why is this court interfere?
That I will go to the inquiry report, my lord, that replies.
This is the report of the collector.
Attendance sheet that is submitted by the ABO also, that is nobody has been absent, my lord. That is also there in my record. And I don't have cotton field. My lord, yes, agreed, my lord. If it is also correct. And then direct disengagement model, that a disciplinary proceeding may be initiated. I have given sufficient time. I have not given copy of the complaint submitted by this thing. Nothing is out of that.
So all that you were not complied with, sir, please listen.
Correct.
All that was not complied with was complied with at the time of hearing before the collector.
No, my lord, I have not been supplied with the complaint petition also before the collector, my lord. And my point is that this is not a serious case where direct disengagement order in the past.
Yes.
What is they shouldn't initiate a discipline proceeding, at least by suspending me or something like that.
No, you were given an opportunity before the collector.
No, my lord. After the order of this only court.
No, maybe.
Before that, my lord.
Maybe.
Even thereafter, I have not submitted given the documents. Even they are not sure whether what is happened on 12/1 or 13. In the counter also they have said. They are confused.
It would have been Sir, please listen. It would have been an empty formality. He has given you what the opportunity was not given earlier, has been given by the collector subsequently. If you did not succeed there, even if such an opportunity would have been granted to you earlier, you would not have succeeded. Yes, what is the stand taken by the state? Let us see. No inquiry?
No inquiry.
Yes.
Since no opportunity was granted to the petitioner and on the basis of the report of the court, that is the sole ground matter for which Honorable Court was that remitted the matter to the authorities to give an opportunity to the petitioner and thereafter to pass it up to the thereafter, my lord, once again the matter was restored, and thereafter the petitioner was directed to remain present, and the other persons who were also who had also submitted their reports, my lord, they were also there. Views were taken, the depositions were taken, and after taking into consideration the depositions, the impugn order, my lord, that is at Annexure 8, my lord, it has been passed. A detailed discussion has been made why he reached to such a conclusion, and when such reports were there, being prepared by the independent authorities, even, my lord. The child CWC report is also there, my lord.
Will the report, do you have a copy of it?
They have, that has been taken into consideration.
That has been taken into consideration.
Yes, you go to the report where they will only informed that, my lord. No such report has been given. They were then
you produce the file
in record, my lord.
You produce the file?
Yes,
I produce there, my lord. File is there, my lord.
My lord, there was the direction to produce the file. There was the direction to produce the.
You have the file with you.
But my lord,
File is there, my lord. Last time also I have given, my lord.
In that case,
doesn't say the report. That is on 13/11.
My lord, that is what my information, my lord. Because this was the other assignments for, my lord. So Mr. J. Mahapatra, from ASU, my lord, he was actually looking after the same. Today, just at 10 o'clock, my lord, I received this particular file. I have received the file in original, my lord, but I found, it seems, my lord, these are Xerox photocopy. My lord.
No, report and the depositions are all there.
No, my lord.
My lord,
This is the report they have given, nothing is there.
But do you have the copies of deposition? Just
my lord, record file has been.
Sorry, that's requested by land.
That is what I submitted. They have last time submitted the report.
Yes,
He come tomorrow. Yes, let him go through the file, and if it is not there, you have to produce the entire file.
I will do that.
Yes.
Item 20, my lord, you coming tomorrow.
Tomorrow.
Let's see the last three orders of my lord. Till that the government has not complied this in.
Put a complaint in me.
Where is the counter?
The counter has been filed, but your lordship directed to file an affidavit. Because my learned senior is producing one documents wherein
This was also, I had heard it earlier.
Yes, your lordship.
Let me.
Let me.
Let me
Let
read the order. Have patience. That inquiry purportedly against that as per information from one of the members of the same should be provided. Yes. Please come to order dated 14/9/2022.
My lord, in response to this same, my lord.
What the collector Balasore is also directed to inform the court as to what action, if any, has been initiated against the said officer. That the affidavit will be filed within 2 weeks. So there were 2 affidavits to be filed.
Yes, ma'am. So, my lord,
Affidavit by the state explaining as to under what circumstances Srimati Tudu had signed on the inquiry report, if she had actually not participated in the inquiry. And further, the collector is to file an affidavit, what action was taken. So 2 affidavits. Are we ready?
The 2 affidavits are not ready, but the information is available with me, man.
I need the affidavit.
In shape of affidavit.
I will give you 2 days time to file the affidavit.
Next.
No. This order was passed, Mr. Patnaik, on 14/9/2022.
I've gone to that one.
So
I've gone to that.
So I have to respect the order of this court.
Yes, because it is to be signed by the collector, my lord.
Yeah. All right. Last one task.
I already
dated 14/9/2022. This court directed filing of an affidavit by the state explaining under what circumstances Srimati Sakramani Tudu,
yes,
CDP of Aliapad, had signed on the inquiry report.
Yes.
If she had actually not participated in inquiry.
Yes.
Stop. Further, the collector Balasore was also directed to inform the court by way of an affidavit as to what action, by way of an affidavit, as to what action was initiated against the said officer for her above conduct. Stop. Learned C. S.N. Patnaik, Learned AG, submits that he is ready with the necessary information and requests for a week's time to file the affidavits. List this matter on 22nd April.
Yes, ma'am.
The affidavits as directed be filed in the meantime positively.
Yes, ma'am.
After serving copy on the other side.
Yes, ma'am.
Item 21.
Lordship, can say the last order dated 8/4/2022.
Mediation has become unsuccessful. You said that the parties are all working in and around Bargad, so it will be easier if the case is transferred to Bargad. Who is appealing for the other side?
Mr.
Jagabandhu Sahu was appealing.
Time, your lordship.
We'll pass it over. Please inform me.
My lord, I am in BC, your lordship.
Item 22.
I don't hear although the Jagabandhu sir, Mr. Sahu is there? Yes, Mr. Sahu.
Yes, your lordship.
I think ଆପଣ ଅଛନ୍ତି କହୁନାହାନ୍ତି?
Yes, your lordship.
Last time you were to take instruction.
My lord, give 1 week time, your lordship.
ଏଇ ଦେଖନ୍ତୁ ପୁଣି 1 week କଣ ପାଇଁ?
My lord, contact କରି ପାରୁନି ତାଙ୍କୁ.
तो आपका पैड को कटा सिर्फ ना
Yes, your lordship. The number जोटा ଦେଇଛନ୍ତି ସେ ଲାଗୁନି।
Sri Jagavant Sahu, Lieutenant Counsel for the opposite party requests for an adjournment. Let's this matter next week.
My lord.
Item 22.
Let here, although the press notice has been issued, but it's a written answer.
Press notice भी देख ला
Again. May I pray, I will say police dusting notice.
दस्ती
Dusting, I can install put say appear କରୁଛି।
दस्ती ना मैंने through police करो।
Through police calling, better.
The office note indicates that the fresh notice has also returned unserved, as the door of the house of the petitioner was found to be locked. In such view of the matter, let an extra copy of the transfer application be served upon State Council. Yes, State Council. And State Council, who shall ensure that the copy of the same is served upon the opposite party through the IAC of the concerned police station.
Right.
Indicating that the matter shall be taken up for hearing on May
6th May.
6th May.
Copy of the writ petition. Copy they do.
List this matter on 6th May. Is there an interim order?
Interim order.
Interim order to continue.
Right.
item 21 interim order to continue.
21 interim order.
Yes, to mention करेंगे.
Right.
Item 23.
Your lordship was pleased to issue notice on the last date.
Somebody has appeared. You have appeared.
Yes.
What is it? Husband and wife?
Yes, lordship.
Matrimonial dispute?
No, your lordship.
Not matrimonial.
No, your lordship.
You want transfer of the civil suit from which place?
Bhavani Patna to Bargad, your lordship.
Bhavani Patna to Bargad?
Yes, lordship. Both are residing in Bargad, your lordship.
Yes. What do you say?
My lord, I will take instruction. My lord, today we are appearing, my lord.
So, without instructions, you are appealing?
No, my lord, here, my lord, there is a legal point. My lord, the land is situated in the jurisdiction of Bhavani Patna.
So,
my lord, I pray 1 week time, my lord.
All right. What's your good name?
My lord, Asim Kumar Das.
See, Asim Kumar Das, advocate, has entered appearance for the opposite party. He requests for an adjournment. Let's this matter on May 13th May. Is there any interim order? Interim order to continue?
Obliged to lordship.
Item 24.
May I please, your lordship? But as per noting, notice is sufficient.
You are
I am
appealing?
appearing for the opposite party. I want quick time.
Why?
I appeared 12 last working day.
Yes, what is this matter? Matrimonial dispute?
Mat case. Transfer of mat
You are
case.
the husband? You are the husband?
Yes.
All right. If this is a matrimonial matter, why don't you have a settlement? Through mediation?
No, just file 2023 file. That case. So already appeared. Another GR case is pending for 90 days.
No, it's all right. But if you can have a settlement, all the cases will be disposed of.
No. There's a trial stage. GR case is trial stage.
So it can't be settled. It can't be quashed. On the ground of settlement. I'm asking you, I'm not forcing you. You may think of a settlement. If the matrimonial basic, if the fundamental dispute is being settled, has been settled. So if you agree, I can send it for mediation.
I am taking instruction.
All right, let's just matter next week.
6th May.
Your good name, sir? What is your good name, sir?
Amir Ranjan Swai.
Sri Amir Ranjan Swai, advocate, has entered appearance for the opposite party husband. He requests for an adjournment. Let's this matter on 6th May. Is there any interim order? Interim order to continue.
Interim order.
Item 25.
In this case, as per footnote, my lord, the notice to the opposite party on.
Yes, notice has been served, but there is nobody has appeared.
Yes, my lord.
Isn't it? As per the postal tracking report, notice on the opposite party has been delivered on 3/4/2024. There is, however, no appearance. In order to grant one more opportunity of hearing, let's this matter on 29th April. Is there any interim order? What I would date the one Yes.
Item 26.
My lord, I pray for 2 weeks time. Last week I am appear on better 9/4/2020.
Matrimonial matter.
My lord.
Settlement?
Settlement, some instruction is required, my lord.
No,
Last week
mediation?
I appeared, my lord. No instruction is received. my lord.
What about mediation? Will you agree?
Criminal proceeding has been filed and a judgment on told आपको 17 execution case already filed. Another case has filed for divorce. The matter was a PRPC number 46 of 2024. That matter was posted to 30th. Both the matters, 35 data matter asu, and we instruction is to
Is this matter on 30th?
along with the 46.
সেটা ক্ষেত্রে আছে along with
PRPC number 36 of 2024.
here PC number 46 of 2023. Is there any interim order?
Yes.
Interim order to continue.
Item 27.
This has come for the first time?
Yes. Last week it was there. My learned friend was doing this.
No, this has been heard earlier.
No, not
This is
exactly. My lord put a question
for fresh admission to
Yes, yes. No point. সেটা পাস ওভার হয়েছিল তারপর টেক অফ হয়ে পারলো
Oh, that joinder of cause of action. Yes, yes.
my lord
ছাড় দিন তো পরে you
হ্যাঁ কাছে
alright ছাড় দিন তাহলে pass over
नहीं कर दे ठीक है और कुछ छोटो के एडमिशन तक my lord put a question. There are multiple prayer. I don't find any multiple prayer there. Subject to clarification.
Maybe I may be wrong. I may have seen wrong.
Well,
If you did not find, I found.
can you read out the prayer?
No, you did not find, but somehow I found. Maybe.
Yes, that question that is why. My lord, here is the case.
ठीक कौन लिखा गया?
Okay.
Was the order of disengagement.
My lord, yes. What happened? I was appointed, continued for leave for certain days. I was sent for the checkup by the board, medical board. Medical board found that yes, whatever the certificate I have given, that is genuine. That means I was suffering. Till then, they terminated me. Kindly see the annexure 10/20.
This is the order of termination.
Yes.
They have conclusion that delinquent teacher is found.
Plans.
Yes. Anyway, terminated में लिखा ना being absent of
Page 20 range. But it is finding only ground of termination is second paragraph page. Whereas Sri Beuria is absent from duty on medical ground for the period from 1/8/19 to 27/10/20, as reported by the block education officer Punta by office letter to so and so. And whereas a so-called notice was issued to Sri Beuria, this is the only allegation. Block education for his prolonged absence from duty. And whereas the reply to the so-called submitted by Sri Beuria transpares that he was absent from due to his illness, and accordingly the medical certificate furnished by him to this office is found genuine by the district medical board. And whereas block education Kunta allowed Beuria to take classes and till the completion of annual so and so. And whereas so-called notice to block education officer so and so through regulation. And thereafter, last but one purpose. And whereas in view of the prolonged absence of Beuria involves gross negligence of duty, and that is why I have been terminated. My respect submission is because illness is not within my control, and I have been taken rest or I was absent because of the illness, and I got a medical certificate. I produced it. They have a genuine doubt on the certificate I have produced, but they found it to be genuine. So, in this view of the matter, termination cannot be warranted in such type of cases. Now I have been terminated. So my prayer is to set aside this order and to grant me all the consequential benefit, including the salary. So my lord, I put the question: what salary you will get?
No, that is all. That for second part.
Yes, second part. Can you see, my lord? I am terminated on 30/10/2023, annexure 10. So that is the after reinstatement. That means after I was declared fit by the medical board. I joined in this 28/10/2020. So at least the 28 কোড়িয়ে রুপি termination পর্যন্ত they could have favored me a salary. Whatever I am, my entitlement is.
Just a little, there is some confusion.
My lord, kindly see.
When were you terminated or disengaged?
এটা হচ্ছে 30/10/2023.
30/10/2023.
Yes, this is the order.
You were disengaged?
Yes. I was absent as it is evident 1/8/19 ରୁ 27/10/20.
1/8/19 ରୁ 27/10/20.
20. This is the unauthorized absence. No, sorry, the prolonged absence.
Anyway.
Whatever it is.
But that is not relevant because you already.
That is ground for which I have been terminated.
Yes.
So I mean, thereafter from 28/10/20 I joined and discharged my duty. I have been sent for training and all the sorry deputation, all of the duty I have given in that. All the orders I have given. But from 28/10/20 also they didn't pay my salary because of this proceeding and all these things. Though it was terminated, order was passed in 23. Say jo 28/10 ରୁ that is they could have given me the salary and given me a go by yes you are terminated. Say period salary भी देना, that is why I am meditating.
So you joined
28/10 again.
And again you were disengaged on 30/10/2023. Which is under
So that is not related to this. And if this ground of termination is only absent for this particular period.
All right.
That is why I prayed.
You will accept notice?
Only state is my friend.
Learned AG accepts notice on behalf of all opposite parties. Let 5 extra copies of the writ application be served upon him within 3 working days. Let's this matter. 13th May. Yes.
This is a small issue, but if my friend will cooperate, then we. So
Password ଅଛି କେତେଟା password ଥିଲା ଆଉଟା କି
password item of 4.
password কি করଥିଲେ তো none appears on repeated calls. List this matter next week. You are there?
On behalf of, is on the way.
Yes, yes.
Dear Mahabhadra is on the way.
You want an adjournment?
One passover.
3 passover is allowed. List this matter next week. Yes.
Passover item 5.
5? Yes, Mr. Mishra. I had passed it over. Again passover. Right, I passover କରିଥିଲି ମୁଁ. I had asked him to go through that
Yes.
week, isn't it?
Passover item 7.
7. The pleadings are complete.
I have placed again.
The pleadings are complete.
Yes, I have placed also. I have placed my part of submission on the last occasion. I am to complete. And Mr. Swain,
Yes, he had.
he has taken time twice. In the meantime, because of his illness and all the things, today he has also asked for a passover. This is that case, my lord. Interest is seniority between me and the client. Over time,
After lunch. After lunch, the weekly list will begin. So,
Not next week. Kali program. Shukra, Guruvar,
we'll call it out after lunch. We'll see at 2 p.m. All right. 2 p.m. देखे. चला.
Passover item 13.
13. Madam Jana was here. Next week.
Item 28.
28.
May I please, your lordship, extension for time. Lordship was pleased to dispose of the matter on 29/2/2024.
Yes.
By directing the petitioner to file an appeal before the ADM cutoff within a period of 2 weeks. In the meantime, lordship, we could not contact the petitioner so that we could not file the appeal before the ADM. So I pray for 2 weeks to further time to file the appeal.
It is submitted that because of certain unavoidable circumstances, the order passed with this court on 28/2/2024 could not be communicated to the petitioner. As a result of which the appeal could not be filed within the stipulated period. Taking into consideration the above facts and considering the submissions as above, 2 weeks further time is allowed to the petitioner to prefer appeal. Stop. It is made clear that no further time shall be granted. No further extension shall be granted. Yes.
From 29. 29 a letter was from the.
4 months further time is allowed to the court below to dispose of the case.
I don't know, 30 max. I have filed application for appropriate direction, my lord. Your lordship kindly see order dated 7/2/24. Para 5, my lord. During pendency of the application, my lord, since charge sheet submitted, interim order was passed, my lord. Interim order was not vacated since charge sheet submitted, and as per he has not complied the order, my lord. So he has not surrendered. Since charge sheet submitted, interim order in force, now the police is not arresting, my lord. Application is disposed of. That's why, my lord.
Yeah, but police need not arrest. Police is not bound to arrest him.
Interim order is there. That's why, my lord. Your lordship indicate that interim order stands vacated.
Lord counsel, कोडी interim order इसे तो किसी नहीं.
नहीं जैसे interim order टा जेंतु थिला, से कोजंदे अच्छी से that was in force. That's why, my lord. That may be clarified.
You see,
yes,
this application was disposed of, granting him liberty to surrender within 2 weeks.
Yes.
Now, if he doesn't surrender, nor obtains any modification, this order goes.
Now the once is no, he is looking. Your lordship clarify that.
No.
What happened, my lord?
No.
And BLAPL is disposed.
Clarify means I will give a handle to the police to arrest him.
Hey, that apart, my lord.
Sir, the interim order merges with the final order. In the final order, I have not said anything about the interim order. I will simply granted him 2 weeks time to surrender. He did not surrender. What happened, my lord? Sorry, so 2 weeks time, if he doesn't surrender, then this order goes. How does the interim order
is not disposed of, my lord? Your lordship kindly see. Not allowing nor rejecting, not disposed of.
The ABLAPL is disposed of granting liberty to the petitioner. Police
interim order टा से कौन की pending थिला बेले से interim order टा continue करतला से charge sheet दे देले charge sheet देला परे से कोजन वर्तमान में
come to paragraph 5. Come to paragraph 5. Learned counsel for the informant submits that after being protected by an interim order passed by this court in the present case, the petitioner abused and threatened the informant, victim for which an FIR was lodged and charge sheet has been submitted in this.
In that case. In that case,
yes, so after perusing the materials on record, including the statement of victim, which suggests prima facie a consensual relationship, the ABLAPL is disposed of granting liberty. So once the ABLAPL is disposed of, the interim order automatically gets merged in it. Number one. And number two, the direction in the anticipatory bail application to him to surrender within not direction actually a liberty. Within 2 weeks.
He has not surrendered.
He has not surrendered and he has not obtained extension of time for modification. So this is all
interim order. Since earlier there is an interim order is not vacated, my lord. Police says, my lord, see that is continuing. That may be clarified, my lord. CBI extension magunanti.
I have filed IF 453 of 2024. And seeking, my lord, only first or second order may be granted. And
it must modify.
That will be changing the entire order. That is not permissible, Mr. Paul. I have passed an order.
Yes,
you may comply with it, you may not comply with it. So what did I say? That order 720. It will be considered on its own merit.
That interim order stand vacated. Your lordship indicate that.
That's not vacated.
Satan clarify no let's arrest moving.
There is no bar
so threatening, my lord. I have another FIR has been lodged against him.
You come up with a separate application, I will consider. You come up with a separate independent application that the police in action, that I will consider. But in this, I will not
CRLMP file ହେଲେ ଆଜ୍ଞା ସେଟା ଯିବ ଅନ୍ୟକୁ
ଯାହା କହୁଛୁ
ନାଇଁ automatically my lord what happened my lord since your lordship not clarified my lord.
I can understand, Mr. Sahu. I can very well understand the motive of the informant and the police. No, this court will never be a party to this. Never.
That may be clarified my lord.
Why will I clarify? Why will I clarify? When I say, when I pass a final order, which from the doctrine of merger, the doctrine of merger, the interim order merges is the final order. There was an interim order. If the police will not, will deliberately misinterpret. This court is not there to clarify.
Lordship indicate that since application is disposed of, no further order is required. Your lordship indicate that.
But no further order about what?
No.
About what?
ସେଇଟା ଲେଖିଦେଲେ clarify.
କଣଟା clarify ହବ କହୁନାହାନ୍ତି ଆଜ୍ଞା?
Since interim order is not required.
This is not your case. You are the informant.
Yes.
You are the informant. This is not your case, Mr. Sahu. Take a legal aspect of it. We cannot pass an order which will be improper. So simply
Disposed of your lordship, my miss case. Since application ABLPL is disposed of, no order is miss case is disposed of. Lordship indicate.
in view of the order passed by this court on 7/2/2024, no further order needs to be passed in this IA, which is disposed of accordingly.
Okay.
Item 31. 31 is not yours, not your matter.
My lord, with a dispose of matter, your lordship, I have filed, I have for extension of time.
Extension of time. For the first time.
Yes, your lordship. Initially, your lordship granted 2 weeks time. Then I prefer 3 weeks.
No, 2 weeks.
ଗୋଟେ ସପ୍ତାହ ପୂର୍ବରୁ ସରେଣ୍ଡର ଆଜ per
from 3 weeks for the time is allowed. ଆଉ କିଛି ରହିଲା ସେ ଯୋଉ ଗୋଟେ ପାସୱାର୍ଡ ଥିଲା 4 item. Item 4 ଗଲାଣି it is too late in the day for item 4.
extra ଟି କରିଦେବେ ତଳ ଗୋଟେ
Item 4.
petitioner is the wife may not file this application for transfer of the
From which place to which place?
from Jharsuguda to Berhampur
Jharsuguda to Berhampur. On what ground?
on the ground of inconvenient as well as the criminal case is pending against them at Chhatrapur. Against the opposite party, the criminal case is pending at Chhatrapur. And the petitioner had been to Jharsuguda.
No, who has filed this divorce petition? This is a divorce petition?
Yes, no. Restitution of conjugal life filed under section 22 of the Special Marriage Act.
Okay.
By the husband at Jharsuguda.
So the parties are not Hindus?
Well, they intercaste. The Special Marriage Act to their marriage were registered.
Intercaste ହେଲେ ତ special marriage act ହବନି.
Registration କରୁଛନ୍ତି Special Marriage Act.
ମନା ନାହିଁ କିନ୍ତୁ I think
ସେଟା ଅଛି dispute. We can take that point before the trial court because we are not. We cannot.
no, whether it's maintainable or not. No, I am not saying that. Take notice. Issue notice to the opposite party by speed post. Fixing a short returnable date, requisites be filed by tomorrow. List this matter on 13th May. IA. Further proceedings in CP number 29 of 2024. Pending in the court of learned judge, family court, Jharsuguda shall remain stayed till the next date.
I'm good.
Item 5.
Item number 5.
List this matter tomorrow. Yes. ଆଉ ଗୋଟେ ରହିଥିଲା କୋଉଟା ନାଇଁ ସେଟା ଆଉ ଗୋଟେ ବିଶେଷ ଜେନା ସ୍ୱାମୀ ସୁଜାତା ଜେନା କରିଥିଲା
ସେଟା ତ ନେକ୍ସଟ ୱିକ୍
ଆଚ୍ଛା I don't your matter is probably in the weekly list. Yes. ଆଉ କଣ କହିବ ୱିକଲି ଲିଷ୍ଟ ଆରମ୍ଭ କରିବା ଆଫ୍ଟର ବିଶେଷ ଦିଟା ବେଳେ ଗୋଟେ ମ୍ୟାଟର ଅଛି ସେଟା ସରିଲା ପରେ
Item 9 I have got the informant.
you allow the court to say last is 2 PM there is a matter I posted I think passover matter thereafter I'll take up the weekly list.
Item 9 I have got the informant.
that boy refused, he did not go to the mediation. Yes, that matter.
Yes.
The CD, they said they have received, but it's not there. So may I pray possible tomorrow?
The CD in item 941 a notice was complied.
May I pray one?
41
Whatever.
For Lagu will pass that order. 41 has been complied with.
My lord, may I pray one thing, your lordship?
Yes.
Item number 1 permitted to withdraw, your lordship.
Item number 1 of the weekly list.
My lord.
Permitted. Your matter, you have the power there.
My lord.
All right. Permitted to withdraw.
No,
I'll take up the entire weekly list.
My lord, just I have one problem, my lord. Mr. Mahanti is of course there, my lord. My lord, 2 o'clock I have a fixed arbitration, my lord. 3 retired Supreme Court judges are there online. I have to do it. My lord. Mr. Mahanti will do it, my lord. My part, can I do it at 3:30, my lord?
Yes. What is the item?
7. Mr. Mahanti is also there, my lord.
That is not a major. It is there. Entire week.
Cryptocurrency. My lord, because Mr. Mahanti is there, my lord, he will.
No, but if we'll begin, we'll take it up at 3:30. Correct. You will be available at 3:30.
3:30. Correct, sir. Kali, but before lunch, ये dita पर से arbitration चलती है. I got call
tomorrow again because now some more matters have been added. Now second appeal has been added to my assignment. So tomorrow I'll be taking up two or three second appeals also. Some urgent matters have been mentioned today, in fact.
Yes.
So maybe difficult before lunch. So today at 3:30. Sir, what do you say? 3:30.
Mr. Mahanti's convenience. More किसी ने आया.
3:30. Yes.
Deeply appreciate.
Again, obliged.
Yes.
I don't know, 7.
20 minutes. 20 minutes. Not to complete it today. If you can continue, we will continue tomorrow. But today I will grant only 20 minutes. Yes. Because the entire weekly list is there.
Yes. All right. Here I am appearing for the opposite party number 4.
There's only one matter.
So there are 2 matters.
Yes.
So far as the first matter is concerned, second matter I have filed the second matter for implementation of the order of the director.
Okay.
My instruction is, in the meantime, the order of the director has already been implemented. And he has accepted the position. I will all those facts.
Yes.
My lord, first your lordship may kindly see the prayer made in the writ petition. Whether it is maintainable or not.
Yes.
That is WPC number 12466 of 2009, the first writ.
Yes.
Under the facts and circumstances, it is therefore humbly prayed that the Honorable Court be graciously pleased to quash the order dated 29/6/2009 under Annexure 1 passed by the opposite party number 2. That is the order of the director. And further, this Honorable Court be pleased to direct the opposite party number 1, 2, 3 to restore the seniority of the petitioner over the opposite party number and to grant him all consequential service benefits by taking his initial date of joining in the college to be 21/12/1992. And last but this paragraph, and further the opposite party numbers 1 and 2 be directed to validate the appointment of the petitioner and to pay the salary components of the petitioner from 17/10/98 as per the Validation Act of 1998, as that have been extended to other equally circumstanced persons within a stipulated period as deemed fit and proper, and pass any other orders. So, my first submission before your lordship is at the threshold. So far as the third sub-paragraph is concerned in the prayer portion, but that is not maintainable, because he says that since his date of joining may be accepted as 21/12/1992
And since he comes under the Validation Act of 1998, because the Validation Act covers the period from 1/1/85 to 31st December 1992, therefore his appointment is to be validated. Now, for a moment, your Lordship may kindly see the Validation Act of 1998. That is at page 276. 276 of the manual. Section 3, validation of certain appointments. Notwithstanding anything contained in the Education Act or in the rules framed thereunder, the lecturers of aided colleges and aided junior colleges who have been appointed on temporary basis against approved or admissible post by the concerned governing bodies during the period between 1st January 85 and 31st December 1992 and are continuing as such, having the requisite qualification prescribed to hold such post, and are in payroll of the concerned college against the said approved or admissible post, as the case may be, shall be deemed to have been validly and regularly appointed, and no such appointment shall be challenged in any court of law merely on the ground that such appointment was made otherwise than in accordance with the procedure laid down in the Education Act or the rules framed thereunder. Provided that proviso is not important, then subsection 2. The lecturers whose appointments are so validated shall be governed by the Odisha non-government colleges, junior colleges and higher secondary schools, granted at order 1994, for the purpose of their entitlement, but they shall be entitled to receive grantinate towards their salary cost only as per the scale of pay admissible to a non-government college lecturer from time to time, with effect from the date of commencement of this Act. So far as section 3(1) is concerned, it deals with validation. Those who have been appointed between that period 1/1/85 and 31st December 92 either against an approved or admissible post, and who are continuing as such and must be in the payroll of the college. This is the first part, 3(1). And 3(2) says that once appointment is validated, then his entitlement will be decided as per the grantinate order of 1994. So, my lord, here, my lord, so far as his prayer is concerned, his prayer is what I have understood, his prayer is twofold. He has first stated that his date of joining should be accepted as 21/12/1992 because the director has given a findings that he was appointed in 1994. His appointment does not come under the Validation Act of 1998. So therefore, his prayer is that his date of joining should be accepted as 21/12/92 and his appointment should be validated as per the Validation Act of 1998 and consequential benefit may be given.
Yes.
But I am citing one judgment of the Honorable Court, and incidentally my learned friend was also there. My lord may kindly see.
No, but what is your objection to this?
But this is maintainable. He has to approach the tribunal. Well, this is reported in 2004, 1 Wheeler, page 256. Here also exactly by interpreting the provisions of the Petitions Act and 24B, your lordship may kindly see the first paragraph. The order of the state government dated 14/1/2002 disallowing the proposal of the college for validation of the services of the petitioner under the Validation Act 1998 in Annexure 7 is assailed in this writ petition. Then may I place the next paragraph 24B? I don't think not necessary. You also may kindly come to the next page, the last paragraph.
Yes.
I did not read so far as the previous paragraph is concerned.
Language of the statute.
The language of the statute under section 24B(1) and 2 read together with the proviso thereto makes it abundantly clear that an aggrieved person whose case for approval or validation of appointment or otherwise is rejected. This is important.
Yes.
Disenabling him from the benefits of grantinate has to approach the tribunal under the said provision for redressal of his grievance. the order of the tribunal also is subjected to appeal to this court under section 24C of the Orissa Education Act. So original jurisdiction is 24B.
No, that's true, but here, this is not his main prayer. His main prayer stems from
To declare him
the passing of order dated 29/6. I'm not.
But I will take your worship to the director's order. The director has given a findings that he was never given appointment in 1992. He was appointed in 1994, and he is junior to the opposite party number 4.
Yes, that he wants to challenge.
That he wants to challenge. Because, my lord, earlier the deputy director passed an order in his favor, directing for validation of his appointment, taking into account the resolution of the governing body, manipulated resolution of the governing body. I challenge that order before this honorable court. This honorable court set aside that order and directed the director to rehear the matter again and take a decision afresh. Thereafter, the director's order came. So, if ultimately his date of joining is accepted from 1992, what is his ultimate claim? His ultimate claim is to get his appointment validated in terms of the Validation Act of.
So you mean to say that would be the consequence of quashing the order dated?
Yes.
Which he has asked for.
Yes.
Supposing that order is quashed, then
yes, because
you will have to approach the tribunal for the second prayer. This is
sum and substance of my.
Yeah, all right,
my lord. And this is not the alternate remedy. My lord, my submission before your lordships is, so far as 24B is concerned, that is the original remedy.
Yes.
And appellate remedy is 24C. FO. Now, so far as merit of the case is concerned, my lord, in essence, his prayer is to quash the order of the director and to accept his date of joining as 21/12/92 instead of 29/12/1994.
So it boils down to the correctness of the order of the tribunal, the director.
Now you also may kindly see the order of the director,
which is Annexure 1.
Annexure 1. It's a big order. I will not take your lordships. I will not bother your lordships by placing the entire order. My lord may kindly come to the findings of the director, findings made by the director.
Actually, a long order.
Page 32.
A very long order.
Long order.
Page 32, yes. While disposing this case.
Other portions are relevant, but since
no, you are free to, but not today. Not all them. 20 minutes, man, for today I set aside. It's not that so rigid. Because of the utilist, I'm saying.
Yes.
At the interest of the bar, not thing. I'm willing to hear. Aji nale Kalipuni schedule chalibo.
My lord may kindly come to
page 32.
Page 30.
Yes.
The last paragraph. This is the findings. In the above premises, I am inclined to believe that with a view to get himself senior to Srimati Anita Tripathi.
You are Anita Tripathi.
I am Anita Tripathi. The opposite party number 4. Sri S.K. Mahapatra has managed to prepare some manufactured documents as the same do not corroborate with that of the college records. Taking the upper hand of the missing of the resolution number 30 and 40, these are the resolution. He has utilized certain manipulated documents to substantiate his stand of appointment to have been made on 21/12/1992 instead of 29/12/94. When the principal of the college categorically denies in writing to the appointment of Sri Mahapatra on 21/12/1992, and the same has been corroborated by other principals because all ex-principals were also called before the director at different times, and this establishes that the appointment of Sri Mahapatra has not been made on 21/12/1992. As the documental evidences are there, he has been continuing as lecturer in political science with effect from 29/12/94 for all purposes. This date be treated as date of joining in respect of Sri Mahapatra. It is clear from the available records that both Sri S.K. Mahapatra and Srimati A. Tripathi were appointed by the college by observing the due procedure as lecturers in political science, and Sri Mahapatra joined on 29/12/1994 and Srimati Tripathi on 14/3/1995. However, later on, the services of Srimati Tripathi were regularized from 22/12/93 to 13/3/95 by GB resolution dated 8/8/97. But the competent authority GB consequently did not make any alteration and modification against the holding of the fourth post by Sri Mahapatra. If Srimati Tripathi was given her seniority from 22/12/93, it is a serious lapse on the part of the governing body. Thus, taking into consideration the pros and cons and documental evidence, it is an established fact that Srimati Tripathi as continuing as lecturers in political science with effect from 22/12/93 for all purpose, her date of joining be treated as 22 petitioner and the opposite party number 4 is determined in the above manner. Now, your Lordship may kindly come to my counter.
Yes. The preliminary counter.
Preliminary counter filed by the opposite party number 4.
Yes.
Well, before I take your Lordships to other documents, one vital document your Lordship may kindly see. The petitioner himself, along with others, has filed a writ petition in this honorable court. That is OJC number 6101 of 1999. Wherein he has categorically stated that he was appointed in 1994. There was no whisper in that writ petition that he was appointed in 92 and his services were regularized. My lord may kindly see that writ petition, that is annexure R/4. R/4 at page 32 starts from page 32. My lord may kindly see. Kindly come to page 33, that cause title. The name of the petitioner, your Lordship will get at page 36. Saroj Kumar
Mahapatra, yes.
Saroj Kumar Mahapatra. Well, all these lecturers of BNMA College, Palyabinda, they jointly filed this writ petition challenging the cut-off date of the Validation Act. Because since they were appointed after 31st December 1992, they prayed for declaring that cut-off date as illegal. Now, your Lordship may kindly come to page 40 of that writ petition. Because so far as the opposite party number, so far as the petitioner is concerned, he was petitioner number 17. My lord may kindly look at the top. Petitioner number 17, my lord got it, was appointed against the fourth post of lecturer in political science on 28/12/1994 and he joined in service on 29/12/94.
Yes.
Well, accepting this, nowhere it has been stated that he was appointed sometimes in 1992. This is his own admission because he has filed this writ petition. And this writ petition, your Lordship may kindly see the prayer made in the writ petition. What they have challenged. Had he been appointed in 1992, then his appointment covers under Validation Act. Why he would challenge the cut-off date? My lord may kindly come to page 48.
Yes.
The petitioners therefore pray that your Lordships be graciously pleased to admit the writ petition and issue a rule to the opposite party to so cause. Why the cut-off date stated in Rule 3.1, that is section 3.1 of the Orissa Aided Educational Institutions Appointment of Lecturers Validation Act 1989 by annexures such and such, will not be declared illegal and arbitrary. And why the letter dated, other things are not relevant. So here knowingly he had challenged, since he was appointed in 1994, not in 1992, this writ petition along with others, he has filed challenging the cut-off date of the Validation Act. Now he says that he was appointed in 1992 by virtue of 2 resolutions of the governing body. His services were regularized and therefore he is entitled to be covered under the Validation Act of 1998. My lord, earlier, this writ petition was withdrawn by the petitioner and others. Then petitioner and one Tapan Kumar Naik, they filed a writ petition before this honorable court, suppressing all these things. And this honorable court directed for disposal of their representation. Of course, order was passed, directing for disposal of their representation within a stipulated time. Taking advantage of the same, my lord, the deputy director passed an order that since they were appointed in 1992 and not in 1994 and their services were regularized with effect from 1992, their appointment comes under the Validation Act of 1998 and directed for validation of their appointment. I challenge that order by filing a writ application in this honorable court. And that order was set aside.
But how were you affected by that order?
Because my seniority is going to be affected. Because I was appointed in 1993, initially on ad hoc basis.
So their, according to you, their appointment, the date of appointment was
earlier to me because of that order. Because of that order, I filed a writ petition in this honorable court.
Yes.
And this honorable court, your lordship, may kindly see that writ petition. My friend has given. Annexure. Your lordship may kindly see first Annexure 9, the director's order dated 13/4/2005, which was challenged by me at page 46.
Yes.
It's a thought order. Honorable High Court in their order number 2 dated 3/12/2003, that is the innocuous order passed by this honorable court. While considering the grievance of the petitioner, Sri Saroj Kumar Mahapatra, lecturer in political science, and Sri Tapan Kumar Naik, lecturer in commerce, BNMA College, Palyabinda, praying for a direction to the Director Higher Education OP number 2 to validate their services in terms of Validation Act of 1998 as prayed for in their representation under Annexure 7 and 8 to the writ petition.
Let us see what is the finding.
Finding is, now your lordship may kindly come to page 47. During the course of hearing of the case, it was necessary to verify the original governing body resolution of the college. So, to ascertain the proceedings of the resolution number 30 dated 17/7/93, in which the petitioners were allowed a sum of ₹600 as honorarium per month, which have been received by them on records, that is acquittance roll from 21/12/92. Their date of joining and resolution number 40. These are the two resolutions which were manipulated by them. Their date of joining and the resolution number 40/98 dated 27/3/98, on which the services of the petitioners were regularized. On verification of the original GB resolution book, it is found that aforesaid resolution have been turned down and taken away from the resolution book, which has been verified to be true. The principal BNMA College, Palyabinda, via the office letter number such and such dated 18/1/2005, addressed to the DHE, has stated that GB resolution number 30 dated 17/7/93 and resolution number 40 dated 27/3/98 are missing, which is a deliberate action to harass the petitioners. During the course of hearing, it was further verified that the petitioners are in receipt of monthly honorarium from the date of their joining, that is 21/12/92. Both the petitioners are drawing consolidated salary of ₹1,000 per month with ₹500 or yearly 50 yearly increment with effect from 96, which has been verified to be correct from the acquittance roll of the college produced by the principal. In view of the above premises, I am of the opinion that the petitioner Sri Saroj Kumar Mahapatra, the present petitioner, lecturer in political science 4th post, and Sri Tapan Kumar Naik, lecturer in commerce 3rd post, having requisite qualification, were appointed by the governing body of the college as lecturer in political science 4th post and lecturer in commerce 3rd post, and joined on 21/12/92 and are continuing as such till date. their posts are admissible and they are getting their management salary from the date of their joining. As per the Orissa Aided Educational Institution Validation Act 1998, the petitioners are eligible to be validated under the provisions of this act. It is therefore recommended that the claim of the petitioner Sri Sarosh Kumar Mahapatra and Sri Tapan Kumar Naik are justified to be validated under Validation Act of 14 of 1998. But basing upon resolution number 30 and resolution number 40, this order was passed. My lord, I have annexed the copy of and the governing body has also filed a counter. Yes. Nobody is there for the governing body, but governing body has already filed a comprehensive counter.
Stand?
They stand that resolution number 30 and 40 on which they are relying upon, on which the petitioner is relying upon, that he was initially appointed on ad hoc basis in 92 and his services were regularized as he was getting 500 or 600 rupees per month as remuneration. The governing body has also annexed the copy of the resolution number 30 and resolution number 40. In those resolutions, no such agenda or no such proceeding is there. Your Lordship may kindly see the counter filed by the governing body. And I have also annexed that resolution. Governing body report.
So for a moment, so this order was challenged by you again?
Yes. Before the site was affected, I challenged that order. And the order of the director was set aside and the matter was remitted back to the director.
Can we see that order of this court?
Yes, Your Lordship can kindly see that. That is my learned friend has given.
92.
He is 92.
92 of the brief.
92 of the brief.
Yes.
The dispute is relating to inter-se seniority between petitioner Anita Tripathi, myself, and OP number 4, Sarosh Kumar Mahapatra, pursuant to order number 2 dated 3/12/2003.
No, I just wanted to know on what ground it was.
Because no opportunity was given to me.
Oh, so again it was heard.
Yes.
And further, because they have not expressed any opinion on merits.
Yes.
That is what I wanted. So it was set aside because gross breach of the principle of natural justice.
And actually, that
was
not heard before the director, and that order was.
Anyway, so now this impugned order has been passed.
Impugned order has been passed. And while passing the impugned order, all ex-principals were called upon to appear before the director. And I have also annexed the statement of all ex-principals who have deposed before the director. All of them have said that these two persons, I am not concerned with the other person, Tapan Kumar Naik, the present petitioner. He was never appointed in 1992. He was appointed in 1994. By manipulating resolution number 30 and resolution number 40, they have managed to, my lord, so far as their date of joining is concerned, as 1992.
So that this stand has been accepted by the director.
This stand has been accepted by the director.
So we will examine these. So we'll have to go examine the order of the director now.
Yes.
We'll continue tomorrow.
Yes.
ये कल अच्छी तो ना कल की चलो मैंने गुरुवार दिन on Thursday the last
गुरुवार के शुक्रवार
गुरुवार
शुक्रवार
शुक्रवार heard in part list this matter on 19th April. You keep this.
Yes, yes.
We'll give it along with your note.
Yes, yes.
You have given anything.
ମୁଁ note ତ ପ୍ରଥମ ବହୁତ ଦିନ ଦେଇଛି।
ସେଟା ଅଛି ତାହେଲେ on record. If it is on record,
दोनों କପିଟା କଣ?
Is a judgment of what is judgment?
I don't think, Mr. Swami, we only have to test the director's order.
Yes, yes, I will place the entire.
Because the factual aspects, this court will not enter.
Yes.
What, Mr.
The informative that your lordship is to be seen. Your lordship is.
If at all there are any infirmities, then it is to be seen by this.
Are you appointment date? Whether my appointment date is correct or his date of appointment?
Yes, yes, yes.
You are, I think that-
I was claiming, he's showing that I was appointed in 1993, that is the director's finding. I have shown the record that I have also placed. Those documents have never been issued. How the manipulation was, that is on record.
There is a claim of manipulation by both parties.
Yes, yes.
Interest and manipulation.
Claim and counterclaim. Let us see.
Claim and counterclaim. All right.
Weekly list item number 2.
One the call. Yes.
Item 5 was passed out for after lunch.
Item that, Mr. Mishra.
Item 5 Kali.
He was there, but he didn't come. I had asked him.
And for the complainant, informant.
Yes, who's for the petitioner? All right, pass out.
Item number 3.
May it please, let me kindly see order dated 5th of February 2024.
No, that matter. Yes. Yes, I mean, there should be no difficulty. This is one partition whether the witnesses have been examined or not. Next matter that the trial is fixed to today, but the court below, before the court below, and therefore he requests for an adjournment. What happened?
No, they haven't been examined yet, my lords.
Why? Why you have to, any idea why they have not been examined?
No instructions to that.
Yeah, yes, Mr. Mishra, you cannot keep somebody pending, somebody in jail indefinitely on the ground that those two witnesses need to be examined and you don't examine those witnesses. How long will he stay in prison?
Lordship call for the record perhaps from the court below. Lordship.
They are repeatedly saying that the identity of those two witnesses need to be kept confidential. That the court has already accepted. Court has given you enough liberty for that. But unless those persons are examined,
I'd examine your lordship directed the government court below to send that if they were examined, the deposition
They have not been examined.
because all other witnesses have been examined.
only these 2 persons are they were left.
The court below shall transmit the copies of these said witnesses field cover if they are examined. Unnecessarily, the persons are in custody. Have you challenged that order?
Yes.
The 207?
Yes,
What happened?
Challenge in CRLMC number.
it's pending, lords.
So it has not been disposed of as yet.
No.
So this court cannot pass any order. So I'll call it next week. I'll ask the court below immediately to inform.
My lord.
On 5/2/2024, this court, considering the submissions made by counsel for the parties, observed that there should be no difficulty for the court to examine the witnesses named Mr. X and Mr. B.
A and B, my lords.
Sorry, Mr. A and Mr. B. Mr. A and Mr. B. It is submitted by Sri Rai.
Yes,
Anshuman Rai.
Anshuman.
Sri Anshuman Rai, Learned Counsel appealed for the petitioner that the witnesses have not been examined as yet. The court below is directed to inform as to why the said witnesses have not been examined. So, of course, if they have been examined in the meantime, the copies of depositions of the said witnesses be transmitted to this electronically. This order be communicated to the court below forthwith.
list this matter in the week commencing 22nd April. All right. Yes, Mr. Rai?
Okay.
Then we'll see.
Gloves.
Item number 4.
Great.
There may not be, you see, there may not be anything in it.
Gloves.
But since the state went to such extent of providing some information in sealed cover for the court without informing the state council, and this court was convinced that there is something serious. And that is why I have,
Yes, ma'am.
when I continued with the detention. But then you cannot keep a person in custody indefinitely without there being any material. Yes. Yes, what is this?
Pleasure lordship, custody since 18/8/2021. In the meanwhile, two of co-accused has been released on bail. Lordship, who
He is not coming on the similar footing. Let's see. He was apprehended from the spot. Yes. You have been the bail order? No. कितने केजी?
701 kg.
मात्र only. So why are you so worried about 700 kgs? कौन है? When Kanaya Biswas was arrested at the spot, you are Kanaya Biswas.
Yes, ma'am.
He confessed that along with the house owner. So that other person, Pushpak Taraftar, he was implicated on co-accused statement, which is you. Now you are claiming bail.
Lordship, praying for an interim bail. I have also filed
Nothing, no interim bail. 700 kgs. Since how long are you in custody?
more than 2.5 years in custody.
More, yes. What is the status of trial?
Has not got, no single witness has not been.
No, are you sure about that?
Yes.
You what do you say?
Your Lordship may call for the trial status report. Because earlier he was released on bail, on interim bail for a period of 3 months.
That is what I've seen.
Due to medical ground, his wife's cardiac problem is there. For that reason, he was released.
All right. The court below is directed to submit a report regarding the status of the trial. Let's this matter in the week commencing 29th April. This order will be communicated to the court below forthwith. Yes.
Item number 5.
Pilot 373.
बंद करो पिलाओ ने.
Senior advocate is conducting this case. We can take it after 7 minutes. I think 3:30.
Along with 7.
Hello?
Along with item 7.
No. After 7, 8 might not take it up. Mr.
7 तक कभी ले लेंगे.
Vijayan.
Aji. Okay. All right.
3:30.
In
फिर पास हो
item,
रहा है.
Your Lordship, in item 8, this is CBI matter. Mr. Naik has some difficulty today, Your Lordship. Maybe taken up tomorrow, Your Lordship, Your Lordship.
Well, pass over to each. It is on the in the list. If not today, then it will be taken up tomorrow. Mr. Naik is on difficulty, so CBI counsel is in difficulty. He is requesting tomorrow. Yes. So it's just pass over. Item 9. That matter, yes. What do you name?
My lord, I am the petitioner in this case.
Yes. 41A notice has been issued by the IO. Comply with it. Then State Council. These are anticipatory. Then State Council informs that Section 41A of CRPC has been complied with in the meantime. In such view of the matter, the anticipatory bail application has become infructuous and is disposed of as such. It is disposed of. Section 41A notice has been issued by the IO, the investigating officer. So you have to
Have you received that notice?
Sir, I have complied with the section 41A notice.
All right,
but
then anticipatory bail application is no longer maintainable.
Sir, police are detaining me for weeks, sir. They're keeping me from morning to evening whenever I'm visiting, and they're keeping me for weeks, and they're never that they're not doing anything. And
So they're not
only for
arresting
1
you.
hour.
So they are
Please
detaining
kindly,
you.
sir, please
Since you have
kindly-
not been, since you have not been arrested, despite being detained by the police, as you say, from morning to evening, since you have not been arrested, it means that your apprehension of being arrested is not genuine. Since 41A has been issued, you will not be taken to custody.
Sir,
And if
my
it is,
only, sir, my only.
why are you interrupting, sir?
Bail
Why are you
is-
interrupting when the court is speaking? Why are you
Sorry, sir.
interrupting? Why don't you have the patience to hear?
Sorry, sir.
41A notice has been issued. The anticipatory bail application has become infructuous. If you are aggrieved by any other action of the police, you may approach the concerned authority. Yes, next matter.
Item number 10.
Item 10. Pass over.
Item number 11.
Item 11, this may kindly come along with BLFL number 63 of 2024. Similar provocative person of arranging a.
We'll take it up next week then, or which is matter week commencing 22nd April along with BLFL number
63 of 2024.
63 of 2024. Yes.
Item 12.
Here the petitioners are in custody since last 2 years, my lord, for commission of offence under section 20B of the NDPS Act, my lord. On the last occasion, your lordship was pleased to release the petitioners on interim bail, my lord. And they have released on interim bail on 14/11/2023 and surrender themselves on before the interim bail period is expired. The fact of the case is like this, my lord, while the present petitioners were standing in the
Interim bail तो होई 1 month होई आपको 1 month ହେଇଗଲା interim bail ତ
1 month interim bail ରେ ଖାଲି ଯାଇଥିଲେ ତାପରେ surrender କରିଛନ୍ତି.
ହଁ ସରକାର କରିଛନ୍ତି
Bonafide person, yet the trial has not been commenced. And on the last occasion, your lordship was pleased to call for a status report of the from the learning court below, my lord.
out of 12 charge sheet witnesses 2 witnesses have been examined and 2 witnesses have been declined by the prosecution. So now 8 witnesses remain, isn't it?
Yes, my lord.
So 8 witnesses will be examined upon.
But I am a local man and inside custody since last more than 2 years, my lord, and we are both the.
Already I have granted you interim bail once. I have granted you liberty. You cannot be granted liberty like that.
But I have never misused the liberty.
That's all right.
But I am in custody since last 2 years. There is no other male member available in the family to take.
No, he expected the child. As director of the court below,
if your lordship will find.
has submitted a report stating that
I will be hard for a.
out of 12, I will hear you. 12 charge sheet witnesses, 2 witnesses have been examined and 2 have been declined by the prosecution. So, thus, 8 more witnesses remain to be examined. Yes, please.
Yes, madam. Your lordship may kindly have a glance through the witness statement of the witness T. Padmanath Dora, who has conducted the seizure, my lord, being the tahsildar of the case, my lord. The case of the prosecution is they found the contraband article from a roadside, dumped in at a roadside field, my lord. But the executive magistrate said he has seized the ganja from the house of the petitioners, my lord. So there is a huge discrepancy in the statement of the. So my bail application may be liberally considered and a linear view may be taken as I am a rustic villager of Malkangiri, Chitrakonda area, and I have been falsely implicated in the case and inside custody since more than 2 years. And I am a bona fide person. I have not committed any other offense during my interim bail and I have no criminal antecedents also in there. So my responsibility is that there is no.
What did he continue?
122 kg, 450.
Come Korea.
And I'm inside custody since 2 years, my lord. I'm no other male member are available in the.
Well, when I have granted you interim bail, it was with the keeping in view the fact that by then you had already completed 1.5 years of custody.
Yes, my lord.
It is not necessary that every time I will be granting interim bail.
No, my lord. I'm not seeking for interim bail.
Regular bail happening. Regular bail happening.
I'm inside custody since last 2 years.
No.
And the trial has not yet been commenced. Only 4 witnesses has been examined. And another 8 witnesses has to be examined as yet, my lord. And I'm a rustic villager, my lord. I have not played any role in the alleged crime.
No, sir.
Next date ko niya jaw.
କାଳେ ମନ ପରିବର୍ତ୍ତନ ବୋଲି କହୁଛନ୍ତି ମୋର
ରହିଲେଣି ଗୋଟିଏ ପରିବାର 2 ଜଣ ପିଲା.
I know my details are not going to change.
Nothing, I've seen my previous order. And seeing my previous order, I understood why I granted you interim bail. Because, and for 1 month. In many cases, I'm granting 3 months, even 4 months also in some cases. Why I granted you 1 month? I now remember. Because there is direct evidence against you. In spite of that, I granted you interim bail. So whatever you have got is enough.
If your lordship will kindly have a glance.
Your lordship may expedite. No, our statement will be the that's already has been.
But my application.
Yes.
A lenient view may be taken.
No, sir. No, sir. No question of lenient view.
We two brothers are inside custody, and there is no other male member
No.
is there to take care of my immediate family member.
No.
And they are losing their. I'm a laborer by profession, and my family members are getting injustice due to. As I'm in custody since last 2 years, and there is nobody to take care of my family members. So that has to be taken into consideration. My only lenient view may be taken. As there is no criminal antecedent, I'm a local man. Even if your lordship will allow me on bail, then I'm not going to misutilize the liberty as granted by your lordship. Even on the last occasion, I have been released by your lordship, and I never misutilize the liberty. So my responsibility is with any restrictions conditions to make it released on bail.
No. The petitioner.
Petitioners.
Division of
seek release on a on bail on the ground that they have been in custody for more than 2 years and trial, and there is no possibility of the trial being concluded in the near future. Stop. Taking note of the delay in commencement of trial, this court, by order dated 6/11/2023, passed in BLAPL number 11-911 of 2023, had directed a release of the petitioners on interim bail for a period of 1 month. Stop. In the meantime, as already stated, trial has commenced with 2 witnesses being examined. So 8 more witnesses remain to be examined. Under such circumstances, this court finds no justification to release the petitioner on interim on bail. Bail application is therefore rejected. Yes. Yes, item 13.
Your lordship may direct for early disposal of the case.
The trial court shall do well to conclude the trial as early as possible, preferably within a period of 4 months. Stop. It shall be open to the petitioner to renew his prayer if trial is not concluded within the appropriate period. Yes.
Briefly, your lordship. Depends on the NDPS Act in custody since 27/9/21.
Yes.
And only 58 kg 200 grams were seized from the present petitioner and 1 Dhanpati Jani.
How many charge sheet witnesses are there?
24.
6 witnesses.
Till 5/10/23, 6 witnesses had been examined.
Yes. It's only 53 kgs.
No.
811 kgs.
811 kg. My lord, what happened? The motorcycle and auto.
Yes.
They are come simultaneously. Link, I am submitting the link. How link between the motorcycle and that auto? The present petitioner is in the motorcycle. In that motorcycle, 2 packets were seized. That motorcycle was registered in the name of one Nakajani, who is the father of one of the accused, who was present in that automobile. That is the link, because the motorcycle, this present petitioner was coming in a motorcycle. That motorcycle was registered in the name of a person, name of one of the person, that is Nakajani, who is the father of a CCL, who was inside the automobile, from where other 26 packets were seized. And total calculation is 811 kg, 300 gram ganja was seized.
My certified copy shows that seizure was 58 kg 200 grams from the present petitioner. Admittedly, there was an auto and they seized something else from the auto, not from the petitioners.
No, you are
Since it-
you are trying to take advantage of the fact that the police has prepared two separate seizure lists. Still then it is commercial quantity.
Yes, I don't dispute that. It is not 811 kgs. And in custody since 27/9/21,
Earlier rejected.
21 years of age.
Somebody was released, Bolu Kindara.
No, Gulkinda not.
He is on a different, he was a supplier.
Bullukinda was not actually
No, he was a supplier.
supplied by one person, Bullukinda.
Yes, yes, yes.
This petitioner and one
So
judge.
because nothing was seized from his possession. Yes, yes. The petitioner is in custody since.
Seven-
I'll grant you interim bail.
Again?
I'll grant you interim bail.
20 देखिए था पर फिर
27
9 21
is in custody since 27/9/2021 in connection with such and such case. The prosecution case is that two persons, including the petitioner, were traveling on a motorcycle with two packets of contraband ganja weighing 15
kg 200
kgs, 200 grams. It is further alleged that at the same time, some further around 26 packets of contraband ganja were also being transported in an auto rickshaw, which was seized. Stop. According to the prosecution, there is a nexus between the seizure of the nexus between the contraband carried in the motorcycle, carried on the motorcycle, and the auto rickshaw. Stop. Learned counsel for the petitioner, however, has produced the certified copy of the seizure list showing seizure of 58 kgs, 200 grams ganja from the petitioner's possession. Stop.
Only one petition, the other one is not in the
It is further submitted that despite being in custody, no, it is further submitted that despite being in custody for nearly 2 years, no, more than 2 years,
2.5 years.
more than 2.5 years. Trial कौन हुई थी?
Trial is now going on.
The trial has
The witnesses are examined.
not concluded as yet. Under such circumstances, and particularly taking note of the long detention of the petitioner in custody, coupled with the delay in conclusion of the trial, I am inclined to take a lenient view. The bail application is disposed of, directing the court below to release the petitioner on interim bail for a period of 2 months.
Item 14. May I please? Allegation against that manors that by assuring to provide a land taken 18,000 rupees from the informer by one Holadara Pujari minors and others minors. And so far the Holadara Pujari is concerned, he has been granted bail.
Who are you?
I am the minor. You lost me kindly find my loss. You lost. Running page 9 you lost me kindly see. Running my 5. The prosecution story in brief is that
how do you know that here it has been correctly reflected?
That is
now how do you know, Mr. Jana? Why are you not ready with the affair? At least that minimum you should have. So all going to farm of the government, but he has not the government program. He had made the payment for accused petitioner Tirupati Kilo. You are Tirupati Kilo.
He is Tirupati Kilo. Petition number 1.
Okay. And what about petition number 2?
Petition number 2, Nadeki omnibus allegations. But
all right. Yes, the petitioner is in custody since
my lords, petition number 1 in 12/1/2024.
12/1.
12/1.
Petition number 1 is in custody since 12/1/2024.
24.
And petition number 2,
14/1.
Since 14/1/2024. In connection with such and such case. It is alleged that the informant Sutti Khilo paid a sum of rupees 18,000 to co-accused Holadara Pujari, who had assured him to provide him land. Stop. Land by showing him a farm belonging to the government. By showing him a farmland belonging to the government. Stop. The petition, the informant is said to have made the payment through the petitioner number one. Insofar as the other petitioner is concerned, nothing much has been alleged against him. Said Hardwar Pujari and others have already been released on bail as per order passed by this court. The petitioner stands on the same footing. Stop. The bail application is therefore allowed. Let the petitioner be released. Petitioners be released. Yes.
Item 15.
May I be proceed? This is it's in the POCSO Act, 106 POCSO Act. I am there for the interim bail matter.
Right, but you, if you are moving for, yes?
Surrender certificate
Yes.
also.
Surrender certificate has been filed in the court today indicating that the petitioner has surrendered to custody on 19/1/2024 after expiry of the period of interim bail, the same be kept under court. It is stated at the bar that trial has commenced in the meantime with some some witnesses being examined. Learned counsel for the petitioner shall produce the copies of the depositions for perusal of the court. List this matter in the week commencing 3rd May, 6th May. Oh, it is 2024 matter. You file it.
Published.
Item number 18.
May I please, your lordship? 2 years, 2 months inside custody. The offense under section 23 2C of NDPS Act, my lord. The petitioner is the driver of the vehicle, my lord.
Where is the FIR?
PR, my lord.
Oh, say PR who? PR who?
I have the document.
Earlier rejected. No, you were granted, I think,
Period of,
interim bail,
so, my lord.
3 months.
My lord.
Then again, no, it was rejected. Then it was granted interim bail. No, after granting interim bail,
My lord.
his main bail application was rejected.
But
Yes.
in the meantime, my lord, 2 years, 2 months inside custody.
Yes, what is the quantity?
Petitioner is the driver, my lord, 102 kg, my lord.
I have already granted interim.
500.
I have already
102 kg.
102 kgs.
No.
I have already granted you interim bail once and thereafter I have rejected it. So what further?
Petitioner is the driver and
No,
the
no.
trial is not, my lord, the whole problem is, my lord, the PO is not available. That is the.
I will expedite the trial.
I
You will be made available, don't worry.
My trial report will be confirmed.
The court below is directed to submit the status. So submit a report regarding the status of the trial. Release this matter in the week commencing 6th May.
Item 19.
19. May I please, your lordship, on behalf of Mr. Mahanti, and lordship on the
number 14, Lordship, while disposing my last bail application on the 4/9/23, had directed the learned trial court to finish the trial by the end of the December. But till now, we are in next year April. The out of 14, Lordship, out of 16, only 5 witnesses.
Out of 14.
Out of 16. Out of 16, only 5 witnesses. Yes, Lordship, only 5 has been examined. And I'm in JC since 25/9/2020. So 3 years and 7 months of JC. Lordship, if I would like to show just 2 to 3 lines. Lordship, page number 11 of my FIR. At the bottom side, the police had admitted that since it was a high moist sensitivity, there was less scope to follow the procedure under section 42 and 50. It's the admission of the police that they have not complied 42 and 50. It's not by argument. And at the bottom, they have stated that they have done the search in the presence of 2 witnesses. And the examination of the witness, I have filed a Lordship, they had completely denied. They have totally falsified the alleged sentences. It's on the page number 19 and 21.
Let us call for a status report from the court below.
Lordship, may I pray for any short date? Actually, his family is on the verge of collapse. It's my personal information. 3 minor daughter and a wife, whether she will stay with those children or will left that family, it is in that state, Lordship.
Yes. The court below is directed to submit a report regarding the current status of the trial, which is said to be in progress. Let this matter in the week commencing 29th, 29th 18. This order will be communicated to the court below forthwith.
I'm obliged, Lordship.
Yes.
May I please? The petitioner is custody from 25 February 2021, my lord. Till date, only 5 witnesses has been examined, and as per annexure 2 series 2, my lord, this honorable court, while not inclined to accept the prayer for bail, directed the court
within 8 months,
my lord. Then
the court below is directed to submit a report regarding the status of trial. Let this matter in the week commencing 6th May. 6th May and 6th. The order will be communicated to the court below forthwith.
Court below has already seek time. Twice or thrice he has seek time. Your Lordship has granted.
The court.
Yes, my lord. Your Lordship has.
Let us find out what is the status, then we can consider. In the other case, he is in custody for more than 3.5 years.
Yes.
That is why I kept a short date.
And is an outsider.
This man is also,
kg.
This man is also an outsider.
Yes, man.
You see, you have to see both sides.
Man.
You cannot keep a person in custody indefinitely on the ground of possessing commercial quantity and at the same time don't conclude the trial. So it becomes pre-trial punishment. That is the problem. Yes.
Item 22.
May I please, your Lordship? My Lord, kindly. Earlier occasion, your Lordship was pleased to direct my Lord and friend to take a instruction regarding that.
As to what happened to the loan of asbestos worth rupees. Loan of asbestos rupees 1 lakh.
Investigation going on. Till date, they have not been traced out, my lord.
And then State Council submits on instructions that though investigation is going on, so far the load of asbestos has not been able to be traced out. So, you are anticipatory bail.
My Lord. That is matter of 1,50,000, my Lord.
So you know you are the driver.
Yes.
Are you not the driver? You were driving the vehicle in which the asbestos was being transported. So who else than you to say? On that ground, I had rejected the earlier application.
May I pray without any prejudice if a petitioner is interested to deposit 1,50,000.
1 lakh?
But that is amount is transporting materials amount is 1,50,000. May I pray before your Lordship without any prejudice if a petitioner may deposit 1,50,000 before the court below.
No, because this order would have been passed on the first instance. I have already rejected it. Second application were filed. There is no change in circumstance. Whatever change is there is against you. That the load of asbestos has not been found. I have rejected it, earlier application.
Like that. Where lots of further that where is that asbestos?
Yes, yes.
I need to take instruction regarding
All
that.
As requested by learned counsel for the petitioner, is this matter on the week commencing 6th Parata कहते हैं? 13th May.
13th
May, week commencing.
May pray to protect.
Already reject already rejected on merits, Mr. Pradhan. How can I?
Any shortcut manner will take instruction regarding the money, your lordship.
All right, 29th April.
Item 23.
May I please, your lordship? May I please, your lordship? Case was initially registered under section 307, 302 along with other offences, your lordship, and charge sheet submitted under section 306, your lordship. And in last occasion, your lordship were directed to obtain the bail order of co-accused passed by London court below.
Court below in respect of?
Jagavanda Sahu and Sanjay Sahu.
Order dated 22 to 24.
Order dated.
So who is Sanjay Kumar Sahu? He is the husband?
Son of Jagavanda Sahu.
No, but who has died in this case?
Died.
Informant's husband committed suicide. Yes, yes.
Informant's husband.
Informant is that lady.
Gunamani Sahu.
What is the allegation? Jagavanda Sahu, Damayanti Sahu, Sanjay Sahu, Sanjay Sahu, Ulas Sahu.
Petitioner number 1 is Damayanti Sahu.
Sanjay and Ulas assaulted husband, wife of Sanjay. Gruesome murder. What is the evidence against this lady?
Allegation is that while the informant and her husband.
Wait, how the assistant sessions judge could grant bail? Huh? 302 नथला कि 302 बोलते नथला ओ
306 मैडम the 306 charge.
Yeah, I was surprised. Charge sheet has been filed on 341, 323, 506. What about this lady, Damayanti Sahu? What the matter against her?
Similar footing, my lord.
Sanjay Sahu.
Sanjay Sahu and Jagavanda Sahu.
The petitioner is in custody since?
Anticipatory value.
Petitioners are in custody since?
Anticipatory value.
Oh, sorry. I'm sorry. No, the petitioners are apprehending arrest in connection with such and such case. The prosecution case is that six persons, including the petitioner, being armed with deadly weapons, entered into the house of the informant and assaulted her husband by dragging her outside. They had the intention of killing him. The co-accused Sanjay and Ulas are said to have assaulted him by means of bhujali and iron rod. The informant, being the wife of the deceased, attempted to rescue him and called the villagers, whereupon the culprits left the spot. She went to the village to arrange money for the treatment of her husband and found her husband dead, found her husband hanging dead from a tree on her return. though the FIR was registered under sections 141, 148, 452, 341, 323, 307, 506, 323, 326, 302, 149 IPC. Your charge sheet has been submitted under section 341, 323, 506, 306, 34 IPC as evident from the certified copy of the order dated 18/12/2023 passed by the court below in respect of
And 1/12/23.
Okay.
And 1/12/23. Two orders are there in that.
In respect of equal accused persons. Stop. It is seen that the co-accused Sanjay Kumar Sahu, against whom there is direct allegation of assault in the affair, has been released on bail by the court below. Stop. Insofar as the petitioners are concerned, they stand on a better footing in as much as no direct allegation, no specific allegation of assault is made against them. Stop. Taking into consideration the above facts and the materials on record, while not being inclined to grant anticipatory bail, surrender release. Yeah.
Obliged.
Item 24, that on behalf of Mr. Satyanarayana Mishra, seek time.
Yes.
On behalf of Satyanarayana Mishra, 6 time, 1 time.
Oh, time. Next week, 22nd April. Right.
Item 25. Ram to Jewelers Miller. At offense under section 427, 341, 294, 323, 324, 307, 354 by 34 IPC my lord. Dispute between two groups regarding taking of water from a tap my lord. In the meantime, your lordship already released the co-accused.
Maggie Ponda. Isn't it? Maggie Ponda has been released on bail.
All are 5 my lord.
Same order?
Maggie Panda, Lotta.
Yes.
Annex malady. Yes, malady.
Same order.
First, it was injury that found to be simple. Thereafter, I filed grievous barla.
Your lordship already modified.
Modified that.
Consider modification. Subject to verification of issue.
Item 26.
May I please? My lord, on earlier occasion, in ABL Appeal number 12212 of 2023, since the name of the present petitioners are not there, it was submitted by the Learned Council, the bail application was disposed of. But the names were present in the affair, my lord. Lordship may kindly produce that that petitioner number 1, Sushant Kumar Sahu, the son of Sibocharana Sahu, he is accused number 2 in the affair. And Santosh Kumar Mahapatra, son of Santanu Kumar Sahu, is accused number 8. And other 2 petitioners, their name are in the 161 statements, and 30 to 40 persons were implicated in the affair. And it is a village dispute with regard to Quran Poribaguni Goro. Specifically, petition number 3. Accused column, accused number 2, accused number 8. Bittu Sahu, a father name Sibo Sahu. He is
Bittu Sahu is here, not the petitioner.
Petition number 1.
Sushant Kumar Sahu.
Oh, Sushant Kumar Sahu alias Sibocharana Sahu.
Where is it?
Alias
Son of Sibocharana.
Yes.
Son of Sibocharana Sahu.
Yes. And 3 is.
No, if I doesn't mention so.
No.
It says Babu Das. Bitu Sahu.
Bitu Sahu, father's name suppose
তার আউ কি বইতো আমি কি জানি
say.
না আমি কি জানি you have not you yourself not mentioned that it is you have not also said also known as কি alias আপনি লিখি না দি alias সব লিখি না দি কি জানি
সেটা seriously জমা পড়িଯିବ clearly আগে।
alright
So 161 ରେ ସମସ୍ତଙ୍କ ନାଁ ଗୁଡା ଆଜ୍ଞା ଆସିଛି 161 ରେ ଜେରକ୍ସ କପି ଗୋଟେ ଦେଇ ହଉନି if my lordship will call for all the names were there
সিটি কম
Petition number 3 ର ନାଁ ଅଛି ସନ୍ତୋଷ କୁମାର ମହାପାତ୍ର ସନ୍ତୋଷ ମହାପାତ୍ର
ସନ୍ତୋଷ ମହାପାତ୍ର father name ଶାନ୍ତନୁ ସାହୁ
yeah that is there serial number 8
serial number 8
other 3 1 2 and 4 not named
not named in the affair but implicated on about 30 to 40%.
no 30 to 40% ର ହବନି ମାନେ there has to be specific ନହେଲେ କେମିତି ହବ
specific ଟା 161 ସେ କହିଛନ୍ତି ତ witness ମାନେ
witnesses ମାନେ ଯାହା ନାଁ କହିଛନ୍ତି ସେମାନଙ୍କ ପାଇଁ anticipatory bail application can be considered
at that time 161 statements were
30 to 40% is too vague
yes so
to come within that what you have reason to believe that he will be arrested
may I pray lordship may call for the case diary so that it will be clear who are being named in the 161 161 of Sheikh Jama Hajari and statement of
let's produce the entire case diary
yes
up to that case diary obtained let this matter to be commencing
379 506
May yes
lordship may kindly protect
lordship next
ଆଗରୁ ଆଜ୍ଞା ସେଟା ଇଏ ହେଇଥିଲା ଖାଲି ନାଁ ନଥିଲା ବୋଲି ଡିସ୍ପୋଜ ହେଇଥିଲା ଲର୍ଡସିପ ହାଜ ନଟ୍ ରିଜେକ୍ଟେଡ୍ ଅନ୍ ମେରିଟ୍ ଶୁଣିଲେନି ଜମା
yes all right no course of action
oblation
Item 27.
May I please the lordship? May I please the lordship? I may be permitted to receive. My lord, the allegation against the present petitioner under
if I do not permit you can you come physically from Baleswar right now no no
against the present petitioner under section 279, 337, 294, 323, 341, 307, 379 and 34 of the IPC. The present petitioner is the owner of the car bearing registration number OD01B7478. There is a case and a counter case in between the
here also same in the affair driver of the desired car and 50 to 60 people and he says he is the owner of the desired car earlier filed
no
not named Liberty.
earlier Arbaz Khan had filed no he was also a petitioner there
No. I am not the petitioner there.
But he is here the owner of the vehicle.
no is his name not there in the file
No, only driver of desire car and number 2 50 to 60 peoples. Page 10.
and what is the office name but he being the owner of the vehicle he may have a
Apprehension.
yes
307 379 is there.
so what is the injury
Injury report is not there, my lord.
obtain the injury report
My lord.
obtain the up to date case diary including the injury report be obtained let this matter in the week commencing 6th May no course of action
28.
Please, your lordship, allegation of offence is 379. As per the co-accused statement, the petitioner was entangled in this case. This honorable court has granted anticipatory bail in ABLAPL number 14099 of 20.
same order
Unknown affair. Unknown affair.
I have granted this relief to one Jittu alias Jitendra Kumar Bholo same order
My lord.
Oblation.
Item 29.
earlier in ABLAPL number 1407 of 2024 one co-accused Siddheshwara Samanta Singh has been extended the benefit petitioner stands and similar
yes
And this petitioner not named.
Not named.
Or Samant Singh. No, my lord.
not named
he has not been named
either of this would have
Ashwini.
what is the name what is the name of the petitioner
Pradeep Kumar Samant Singh.
Samanta Singh
not mentioned some Samanta Singhar is there but
and others
and others say କଣ ହବ
Hey, ଯଦି ନାହିଁ ଭଲ କଥା my friend will say that my name doesn't appear my apprehension is but
yes what do you say one of them has been granted benefit that's this or Samanta Singhar because he has been named in the affair
Siddheshwar Samant.
she has been named.
Yes. Been named.
And another, what was that another?
Yeah, others person.
No, in that bail application.
Acha.
Along with Siddheswar Samatrika and another Lekhaika, who is that another? All right. Yes, what do you say?
353 allegation, 354.
Same order.
I think 30.
ଏହି ମ୍ୟାଟର ପାଇଁ ଆପଣ ସକାଳୁ ବ୍ୟସ୍ତ କରୁଥିଲେ କୋର୍ଟକୁ
ଫାର୍ଷ୍ଟ ଲିଷ୍ଟ
ମୁଁ ଜାଣିନି ଆପଣ ମାନେ
ଫାର୍ଷ୍ଟ ସେକେଣ୍ଡ ଜାଣିନଥିଲି ଆପଣ ୱିକ୍ ଲିଷ୍ଟକୁ ବିଲ୍ ନଥିଲା ସବୁବେଳେ ରିଟ୍ ପିଟିସନ ଥାଏ ତ ସେଇ ହିସାବରେ ଭଲ ଏଇ ଲିଷ୍ଟ
ୟେସ୍
ମେ ପ୍ଲିଜ୍ ୟୋର ଲର୍ଡସିପ୍ ମେ ପ୍ଲିଜ୍ ୟୋର ଲର୍ଡସିପ୍
ଏଠି 3:30 ବେଳକୁ ଗୋଟେ ମ୍ୟାଟର ନେବାର ଥିଲା
Yes, my senior is waiting.
Yes. Are you ready, sir? Or Mr. Kanango was
We are almost finished. What I am ready.
no, Mr. Kanango is here virtually. So I was waiting. I have allowed 10 minutes to pass only because you were not there.
No, I was here.
No, I thought you will come at 3:30. That is why since I didn't see you. So let us hear that. What is this matter? It has been called out. Kali Gota Sarda.
NDPS matter achi on the basis of co-accused statement he has been implicated by lord. Running case number 8 my lord. Kindly have a glance.
Plain paper FIR nahi malad. Only that contents. FIR content. Plain paper FIR not filed.
It is only available. The lower court of available.
Na semti kunti hobo.
Plain paper effect asunati.
Na.
It's a person. Either last time thila ki matter na?
No malad. First time.
First time. Then you open the case nahi?
My lord. The interim protection matter.
No.
Co-accused statement
Kete kg?
मतलब 2 program में लिखा है they both admitted that they have collected contraband articles from one Tinku.
No, we have not seen the entire thing. How can we know? I'll fix a short date maybe. Up to that case that you opened in this matter in the week commencing 29th April. Yes. Call out that matter.
Item number 7. For a week. After that.
Yes, Mr. Mishra. He is requesting for one more week. 6th May.
Uncle next I should take advantage.
No.
Otherwise, I am no.
Yes. Item 40. Yes, it is passed over. Otherwise, it would have reached, but only because of this matter.
Rest of the matter tomorrow.
So continue very well list. I think you had completed last time.
Almost.
Cryptocurrency.
I had shown the judgment, your lordship remembers.
Yes. That association or something like that. Yes.
Internet and Mobile Association. Where
Mobile, yes. No, what order was passed? I had directed, I think. This is
Your lordship directed to take instruction and place before your lordship
161 statements.
161 statements where the inducement and the enforcement has been specifically named.
Yes.
Millard, I have not only brought 161, I have also brought 164 statement.
my friend starts, my lords. In addition to what Mr. Mahanti says, my lords, if I have induced someone to invest in cryptocurrency which is legal, then my lords, no illegality can be attributed to my action. That is my stand, my lords.
That you have taken from the very beginning, that it is legal tender, so even if I deal with it, it will not amount to anything.
Actually apparent from the charge sheet also, my lord, wherein they have stated, my lord, the modus of
Charge sheet has not been filed.
charge sheet is filed, my lord.
It's been filed. I mean, filed in my, not available in my record.
Yes, already filed, my lord. It's noting last sheet. I have filed charge sheet. Ticket one.
Final from right.
Yeah. Well, charge sheet, page 54 starting.
Page 54 of the charge sheet. Page number 9 taro.
Eta tolugu.
ଶେଷକୁ ମାନେ ତ portion କୁ ଅଛି page number.
ଏଠି ଦେଖାଯାଉନି ସ୍କାନିଂ ଅଛି ଗୋଟେ ଦେଖାଉଛି ଗୋଟେ 54 ତ
ଆଜ୍ଞା. 16.14.
16.13.
Much.
Lord,
during investigation, it was ascertained that investors of STA, where STA is supposed to be the cryptocurrency.
No, STA is not getting.
Were to invest a minimum amount of rupees 3,000 to buy STA tokens through Trust Wallet, which is downloadable both in Android and approved Play stores. Many of the technical unsavvy people who are unable to download Trust Wallet or operate it transfer money to the accounts of the top leaders and also handed over cash to them to purchase STO tokens. Here it is pertinent to mention, this is important, internationally acclaimed. After the purchase of USTD, one can buy STA token from Pancake Swap and La token site. So first you have to convert it to US dollars and then you will buy it from the exchange. And cryptocurrency, as I was stating to your lordships earlier, is a virtual currency and is a recognized form of government law. And Mr. Kanungo has given that decision, wherein and clarification by the Reserve Bank of India as on date, I have checked up the website, it says that cryptocurrency has not been banned, nor that yet the Reserve Bank has found any guidelines to regulate it. Well, that decision says,
Sir, there was another, I think the IO herself had stated, dealing in cryptocurrency as such per se may not be illegal, but what you have done is...
I'm just taking directly to your lordship to that if you purchase the materials with cryptocurrency, that is how I understood the last time she was making a submission, that money is a legal tender. If you purchase goods from the market with cryptocurrency, that is an illegality.
No, that is not exactly, but...
And you have purchased, allegation is that I have purchased some electronic things were purchased from him. But your lordship may kindly see page 59, the allegation.
Of the same final form?
Yes.
Yes.
16.28.
Yes.
Regarding the legal tender. During investigation, it came to surface that there has been huge transaction in the bank account between Nirod Kumar Das and its offline members, namely Gupta Singh Sindhu and one Sushil Kumar Tondre, which clearly shows that money under STA has been circulated among offline members, clearly showing offense under the such and such. During investigation, it was ascertained that Nirod Kumar Das was promoting STA token as a legal tender, and this is by purchasing electronic goods through STA token, which is not only illegal but against the rules and guidelines. Your lordship was probably referring to this submission. This same fact was ascertained by the statement recorded under 161 CRPC of one Manas Patra of Bhadrapur. Now, Manas Patra statement, may I place it before your lordship? She's last, whatever I said. Yes. That's it, please get this in. Parallel page sculpture.
Statement of Manas Kumar Patra.
Statement of Manas Kumar Patra. I read it out.
I have it with me.
I Manas Kumar Patra. Manas Patra, stated by the IO in the charge sheet that Manas Patra statement reveals that was used as a legal tender. Now let us see, my lord. I, Manas Kumar Patra, aged about 35 years, state before IO that I have an electronic shop by the name of Ma Electronic Market near Mahtabchar, Bhadrak. I have done MBA in CB Raman Engineering College. I know Nirod Kumar Das, Odisha. He introduced to me one crypto digital currency by the name Solar Techno Alliance, who happens to be the district and Odisha head of solar technology. He convinced me about the benefits of putting fund in STO token, and I needed additional funds to invest in my electronic shop. I was allured by his talks and invested an amount of rupees 3 lakhs in the month of April 2023 and gave 3 lakhs cash to Nirotwa Das. I have 3 lakhs an amount of 3 lakhs in the month of April. I have 2 wallet IDs, such and such. He added me to WhatsApp group by the name STA Champions, in which he is present. And I came to know that one David Gage is the CEO of the STA Delhi at 8:30 p.m. There is Zoom meeting on WhatsApp in which people are motivated by Nirotwa Das and Gurtesh Singh, contribute to increase their network under them to receive more, become as referral, and also not to withdraw STA tokens but to stack it. In STA championship, one top leader of STA, namely Sushil Tuddu, said as crypto expert during mobile now is present. Here I further state that Nirotwa Das holds the monthly program in promoting STA. And at Narendra Royal's Mandap near Ban's Chak of Bhadra in front of DRD office under his patronage, where more than 1,000 members used to attend. I came to know that the district head of Nirotwa Das has earned more than 18 crores of rupees, which has invested in land and buying boss, and the said fact is being discussed among the members of the STA. I further state that one Niranjan Nath, Krishna Chandra Sahu, and Golok Bihar Behera of Bhadrak have earned substantial wealth from STA. I further say STA token operates as a multi-level marketing scheme. One who gets enrolled as a member under any offline member needs to enroll at least 4 or 5 members, or else his ID trust wallet is deleted. Most of the time, as investors do not know how to operate the wallet ID or download our senior offline members take cash deposits to open their trust wallet ID. Nirotwa Das is doing this since long. He took cash and transferred his new. Offline members have different sources of earning from STA token like referrals, farming, royalty, matching, and staking. Every member is asked not to withdraw STA token for 20 months by Nirotwa Das, district head of STA, Gurtesh Singh, country head, and David Gage of Europe. Anyone going against their direction are removed from their group and their ID is blocked. The offline members have been living a royal life with big cars, bungalow, and land. Recently, the STA blockchain was launched in Goa. Then I further said that nobody is that electronic purchase. From whom I purchased.
Last night I stated that Nirotwa Das and Golok Bihari Patra purchased one hair dryer and water coolers from my shop by giving me STA token.
How did he accept? Has he been made an accused? Water cooler. Clear lagi कोटी टंका STA token to place करेगा किसी सरकार ने. Why did he accept STA token when he has himself had the 2 wallets and ID? And he says that I have invested money to buy STA. STA token ta se kenti degree kinla. US dollar ru anibo ta nare ID ta upun hobo na. ଆଉ କାଟି ଏମିତି ତ ଏକ୍ସଚେଞ୍ଜର ମାନେ ନେଇଯା ଗୋଟେ STA ଟୋକନଟା ସେ ଟୋକନ ନୁହଁ ଗୋଟେ କାଗଜ ନୁହେଁ ଯେ
Yes.
has to be converted into US dollars, then cryptocurrency can be obtained. It is a very incongruous and general lines that ଲକ୍ଷ ଲୋକ ହଜାର ଲୋକଙ୍କୁ ମୋଟିଭେଟ କଲେ, ଲକ୍ଷ ଟଙ୍କା ନେଲେ, ସେମାନେ ଗାଡି ମଟର କିଣିକି ରହିଲେ, ଲକ୍ଷ ଟଙ୍କା ହେଲେ। ତମେ କେତେ ଟଙ୍କା ଦେଇଛ ଏବଂ କେମିତି ଦେଇଛ ନା କ୍ୟାଶରେ ଦେଇଛୁ? Meaning I can say that I have given cash to anybody, any amount. That doesn't prove anything.
Yes. Yes, Mr. Bhuya.
Just before Mr. Bhuya starts, my lords,
Yep.
what Mr. Mahanti has said, my lords, I'm just adding to it. My lords, it is not hard currency. Je mu Nelly, I take the electronic goods. It is passed digitally, computer to computer. My lords, for a person to investment is made, it is also reflected in the charge sheet. Person to platform. And thereafter, my lords, computer digital. My lords, Bitcoin is, my lords, even a Mercedes car or my lords, any luxury item can be purchased through Bitcoin. There is no illegality in it. And this is not hard currency. Electronic goods and it goes from trust wallet to trust wallet. Has the investigation ever gone into that, my lords? And if I have purchased certain goods and he has accepted the token, nothing illegal, my lords. The VC has been found to be legal by the Supreme Court. So what illegality is there? Even if let us say this is correct and true. In addition to what Mr. Mahanti says.
The first it was investigated by crime match. Then you do WT cover. The first IO, if your lordship goes through her statement, let us say all are based on presumption. I think, I have a strong suspicion, I believe. Suspicion can take the place of.
Yes, Mr. Bhuya. A brief reply to that because we are already hearing. In order to caution that if I cannot conclude it today, the responsibility lies with Mr. Pranam Senior Counsel. Because if you were present, sir, I took it, I thought you were not present, so I delayed taking of the matter by 10 minutes.
My lords, I have Jemdevil arbitration Salah came to your lordship.
All right, sir. All right. Yes. What is your preliminary reply? So first, you must satisfy one thing that not satisfy actually. You have to respond to what they have said. That probably there is a wrong perception about the operation of the cryptocurrency, which has led the EOW to believe that it is illegal. Even though this Supreme Court has held that it is illegal tender.
Here, my only clarification is that here it is not crypto. My entire allegation is that they allured the people that they are dealing with the crypto, allowed the people to invest, but in fact they are running a pyramid-like structure like Ponzi, and your lordship will be satisfied from this table which they have circulated.
It is
Block, this I have given for your lordship's Millard. I have got a copy for myself. Lordship may kindly see. That was the brochure they are circulating, Millard. Lordship may kindly see. So how they are operating, Millard? Millard?
It doesn't form part of the church.
But they're just explaining.
So Lordship may kindly keep it that they have operating that royalty bonus will be like this manner, Millard.
I've seen it. I've seen it.
My Lord and Senior is appearing for the country head, Gurjit Singh, Millard. He is a Kohinoor. Your Lordship will get on the last bottom of the royalty bonus. He is the Kohinoor branded person in that organization. He will get 2% daily of the total investment. The state head, which my own friend Mr. Kanungo is appearing, he is only in the rank of blue diamond.
Diamond hub.
Diamond?
Hub. Diamond hub.
That he is getting 9%. So they are alluring the people to invest under them. So he is operating from Bhadrak. Mr. Kanungo's clan, Neo, he was operating from Bhadrak. His duty is to collect as many people from Odisha to invest under him, so that he will get 9% of whatever the investment made in that STM. And he transferred the money to Gurtej, which my Learned Senior is appearing for him. So whatever money from Odisha and other state given through Gurtej Miller, Gurtej will get 2% of that royalty bonus.
That should not be anything wrong here.
Miller, they are, Miller. That I am, Miller, had it been a crypto, Miller, there is no middleman. You open the, from the computer, the account, keep a wallet for yourself. Nobody in the earth will know how much you have invested, how much money you have invested. That is legal, that is the Supreme Court said. That the person investing with an open eye is taking a risk. Am I clear? Here, in crypto, they are directly investing in the account. Their own wallet is there. They are purchasing directly US dollar and letting them to invest in whatever way. They will only get an assured interest, which is given in their website. That is crypto. That is Supreme Court said legal, justified, valid. Here,
Supreme Court was never provided. My friend has not gone through that decision. Supreme Court has only stated that it cannot be prohibited. And regulatory measures are not there. That's all.
Supreme Court, those were not
the findings.
The finding is there, my lord, your lordship, my learned friend Mr. Kanun has given that decision of the Supreme Court in Internet and Mobile Association case, my lord. There the Supreme Court held, it is as such true that diseases are not recognized as legal tender, as it is true that they are capable of performing some or most of the functions of real currency money. Since they said that it is not currency, it is not convertible to Indian INR, so it is not illegal, and therefore, since the taxes are being paid on the income, it cannot be said that the earning through that crypto is illegal. That is the conclusion of the Supreme Court, and RBI has not regulated them. But now the state of that is financial is to FIU, which is Financial Intelligence Unit of Finance Department of Central Government, has, your lordship, kindly keep it here. All of them said they act through BINAC. BINAC is a platform who Binance. Binance. BINANC. They deal with, they provide them the US dollar platform, the platform. So they say this central government of India, they have banned.
No, but what I will just try to consult the argument is, what is the allegation against them? What have they, how have they cheated anybody?
Exactly, Millard, that is in this time applying, replying, Millard. They have induced people to invest through them. They say, your lordship will get that there is a period which is called lock-in period. Within that period, they cannot withdraw. If they are unable to persuade other people to invest under them, then their ID will be blocked, they will not be paid a single time, though they have been assured with a bonus. So there is a promise given that if you invest, you will get this much of percentage, and once because they knew that pyramid will one day fall, it cannot continue geometrically, it cannot continue, it will spread over the world. So after some time, the pyramid or Ponzi scheme is going to fail. So what they did, they allured the people to invest through them. If I collect other 2 or 5 investors, I will get a bonus for myself. And at the same time, this state head will get a bonus, the country head will get a bonus, which is not there in the crypto. It is in a pyramid scheme. They knew that it will fall one day. It is practically not possible to cover the entire population of the world also, because the pyramid is going on. So whoever failed to persuade others, his chain will be blocked. He will not be allowed to pay a single fine, even not his investment. Exactly that what happened. Therefore, the people came before us and lodged complaint. We have invested whatever hard earned money. So the informant said that he went to Surat, earned money during COVID, returned, and whatever he has gathered, he has invested with the assurance that he will be paid a particular percentage of return month-wise so that he can lead a happy life. With that assurance, they have allowed the people to invest million. Once this investor invested the money, they fell into their trap million. Then they started saying that unless you bring other investor ordering, then you will not get the bonus. That I have given you Lordship, may kindly see what they have.
Bonus not the.
Again, bonus no pile return with even kindly sir. Stacking package conditions. This these are the leaflet. They are, it is their leaflet, Miller. They say upgrade will be based on total stacking. That if current package is 30 USDT and user upgrades with 100 USDT, then his current package and the slab will be of 200 USDT. User can start with any package as mentioned in the above slab. User can upgrade at any time. So they say starting bonus will be given to them. So whatever they
After making this promise, they have
never returned. And the will see this state head, Nero, he has to his account more than 18 crores, which my London friend Mr. Kanungo is appearing. He has amassed the worth wealth of rupees 18 crores and above. Apart from other immovable property, vehicle, etc. And for the for my London senior is appearing for Gupta Singh, he has taken more than 1,000 crores throughout India, and he by the persons hard-earned money. They are cheating those people. They are leading a very lavish life, and he is maintaining his family and children abroad. Once this person is given a go by Miller, and the investigator is 100% sure we can never get him, Miller. He has the operation throughout the globe, Miller. It is said that the head office from very beginning, these investors were given to understand that their head office, they operate from Iceland. But it came to, from investigation, they came to learn that this Gurte is the investor, is the person who has started this money in India, this plan in India.
Well, it will continue tomorrow. Tomorrow means our business argument.
No. I'll grant you,
Mr. Bhuya, I'll grant you 10 minutes. And then reply.
Yes.
So, we'll continue tomorrow. Tomorrow I have kept another part matter to tomorrow, that is an education matter. It will be taken over at 2 p.m. If it is completed, sometime subject to availability.
I also have part that matter.
Tomorrow at 2 p.m.
Because they are not just, I don't know when you will take it over.
And we adjust accordingly. That's
holidays are the best days for Mr. Bhuya to earn money. I have gone to his chamber and seen the last holiday. So he is telling